sideways. Everyone ready, charged up, got your snacks, we're all ready to roll. Okay, so this is a declaration of Respondents Council, RE lodging of going to the just kidding. We're not. We're going to the courtroom. Thank you, Tammy. So
this is starting on page 6. Because that's really where it all.
Yeah, I was just gonna read the top part. Well, Bailey,
that's fine.
Unless Bailey, do you have it, or do you have it now? Yeah, order in the court. Yolanda! Time for jury duty. Bailey, did you get the email or no?
Can you hear me?
I can now.
Oh, there we go. I said yeah.
Okay, you got it? Okay, perfect. Well then, we can start in page 6. Because the rest of it is all just kind of nonsense. So again, I want you guys, I always like to say this.
I'm going to turn the comments off.
We are reading, you guys, directly from the transcript. This is the transcript. I'll go over who's who again. This is the transcript from August when they were in trial. So this was typed up from the court reporter that says what the judge says, what the attorneys say. We love them too, what the witnesses say, etc. So we're going to read them out. So anything we say, we will stay on script. We won't make side comments until we do breaks. We are going to stay on script. But I just want you guys to know this is not our thoughts, our opinions. This is not what we're saying. We are reading verbatim from a transcript that is typed up. Okay? We are starting from the beginning. I am the judge and a witness. So whatever witness is on stand, I will be that witness and I will tell you who it is. Principal, you want to introduce yourself?
I am John's attorney, Miss Taylor Budnick.
And Miss Bailey.
I am Miss Fonseca, Bree's attorney.
Okay, so here we go. So this is from August 27th, 2025. Honorable Nicole Bershon, that's me. PM session. Appearances. Petitioner being present, represented by Taylor Budnick, attorney at law. Respondent being present, represented by Lindsay Fonseca, attorney at law. The court, me. We're back on the record in the Geezy matter. Can the parties make their appearances again because we have a court reporter?
Sure. Taylor Budnick for the petitioner John Geesey. He is en route. I will waive his appearance so we can get started until he comes in.
Okay.
Lindsay Fonseca for respondent Brianna Lynn Olson, who is present and currently sitting in the witness box.
And Ms. Fonseca was very busy over lunch preparing.
My paralegal.
Your paralegal was very busy over lunch preparing the transcript. Have you had a chance, Ms. Budnick, at least to look at the video?
I did, actually. I have much more information now after the lunch break.
Mr. Geesey, if you can join us with counsel. Oh, and this is John. All right, I assume. Oh, no, that's me. All right. I assume you are going to be playing the video, correct?
Uh-huh.
And we're going to get the computer up. All right. So now, what are we going to market? Do you know what your next in line is, Ms. Fonseca? What do you want? Want to make it FF?
No, I have spots left for it would be HHHH.
4 H's? Okay.
And we are on both sides going to go through at the end and mark and move everything since we weren't doing it as we went, right?
Sure.
Okay.
So you're going to be playing something that you had marked as HH and noted Ms. Budnick's continuing objection, and I'll hear more from her once. You're going to play a video HHHH.
Uh-huh.
Exhibit HHHH is marked and for identification and played in open court and not transcribed herein.
And then just so you can see the date.
Okay. So you are going to ask your client some questions.
Yes.
Redirect examination.
Brianna, is this John's TikTok page?
So now, you guys, now I'm Brianna. Yes, it is.
I would object on the same basis.
Judge. Lack of foundation.
Yes, lack of foundation.
He's already testified about his online TikTok page name.
Let me see it again. Hold on.
And I
Hold on.
went through.
No, but counsel, you can't. A person who doesn't maintain that page cannot testify that that is indeed his official page. She can testify that she has seen it, seen videos in his name, and that's the most that she can testify. She didn't create it.
Right.
Okay, so let's put it back up so I can see.
The whole page or...
Okay. Do you recognize what that is? Everything in there? Do you see the 2K up top? What does that appear to be from your understanding? Now I'm Bree. That appears to be an on-screen social media name, Judge. Or Judge. And you know that because you've watched multiple videos and you've seen videos affiliated with 2K. Can you just push it down a little bit so we can see the top? It says 2K at the top. Have you seen other videos on that page depicting Mr. Gacy? Bree, yes. This is the judge. And you've watched other videos depicting Mr. Gacy on that page? Bree, yes. Court, okay.
And did you hear the lyric about the X?
Yes. Now I'm back to Bree, guys. Sorry.
Did you understand that to be a lyric about you?
Yes.
Why was that your understanding?
Because he said publicly and personally to me that I've been the only girlfriend he's ever had, so I would be his only ex.
And you testified earlier that the first time you saw this video online was the day before the custody dispute?
Yes. Now I'm the judge. And when you refer to that, you're specifically referring to that line of 23 seconds where he says, okay, my ex in the place, she gonna pay for that shit. Is that what you're referring to? Bree. Yes. Judge. Okay.
Okay, so back to the date of March 25th. So you said earlier that nobody came to your house on the 24th to serve you with the order, correct?
Correct.
And the same thing the morning of the 25th?
Correct.
And when, in the clips that we saw when you noticed that the police were outside, who were the men that were talking in the room with you?
Those were my managers at the time.
And can you give, I guess, just their first names?
Jordan and Itai.
Were they instructing you on what to do with the police encounter outside?
Objection, leading.
Overruled.
Were you listening to their instructions during the police encounter?
100%.
And why were you listening to their instructions?
Because it was kind of like under their supervision. It was their house. They were my managers. I was trusting them with what they were saying.
And earlier when Miss Budnick asked you in one of the clips where we heard a female voice on the phone, she asked you if you were talking to a lawyer. You were talking to a lawyer on the phone in those... Were you talking to a lawyer on the phone in those clips?
No.
Do you know who that person was?
I think it was a family friend of my manager, Jordan.
Was that person giving Jordan legal advice?
Objection.
Hearsay.
Hearsay lacks foundation relevance.
Sustained.
Were you listening to the instructions from the person on the phone?
Yes.
Did you have a lawyer of your own to call at the time?
No.
And did you believe that you were doing the right thing listening to that lady's instructions?
Yes. Now I'm the judge. Are you going to try to assert some kind of defense that there is a defense to this because she did? She was listening to someone and somebody told her to do it. Is that what?
No, I guess this could be impeachment or just addressing their testimony of them trying to say that this was all done intentionally to get a rise out of John.
I see what you're saying. So this is impeachment of the claim that they introduced that she did this intentionally to get.
Correct.
Okay.
And because, again, it was their videos of this whole streamed incident where we have all this crosstalk that they have now put into transcripts and put before the court. So I know it's hearsay, but how she interpreted it is technically not.
The only thing that I paid attention to, again, for the truth of the matter asserted, are statements that Miss Olson said.
Uh-huh.
So I believe there is a statement in there to the effect of she did this to get a rise out of. So your testimony that she said about listening to someone potentially could impeach that she was done intentionally.
Oh, you're talking about the later piece. Okay.
I think.
Yeah, you're talking about the podcast.
Yes.
So I'll go to the podcast then. So the podcast that the judge just mentioned, when was the podcast filmed?
Now I'm back to Bree. Sometime in 2025.
Was your testimony earlier that you had a script for that podcast?
They did provide me a script, yes.
Who is they?
The people that ran the podcast.
And did you have to follow the script during the podcast?
Yes.
Do you know what would happen if you didn't?
Objection. Speculative.
That's sustained.
Okay, so do you recall John testifying that last November you took Winter from Texas? Are we saying his name or Baby W?
W if you can, but it's hard when we're reading. It's hard to say. So if you say it, it's okay. But try to say
Okay.
W if you can.
Okay, do you recall John testifying that last November you took W from Texas to California, or was it the reverse? I'm sorry, I don't remember.
I remember that. From California to Texas.
From California to Texas. Okay. And last November, when that occurred, did John file an ex parte motion over that incident?
No.
Did John release a music video last November by chance, to your knowledge?
No.
And did John file a restraining order last November against you?
No.
Do you recall seeing the clip that Miss Budnick showed earlier today where you're wearing sunglasses and talking to your chat about kidnapping?
Yes.
Were you being serious when you said, I'm gonna go kidnap my kid?
Objection. Leading.
Sustained.
Were you being serious as to any comments you said in the clip that Miss Budnick showed?
Objection. Leading.
That's overruled. I can answer? Yes. Sorry, overruled means you can answer. Now I'm Bree. No, I was actually repeating comments that I was seeing come across my screen.
Okay, I don't think I have anything else.
Okay? Ari,
Just a couple.
cross-examination.
You had testified before the lunch break that this music, the song that you have discussed, Mr. Giese posting to social media in March of 2025 referenced Mr. Giese using rugs, and you declared Tesla as sort of, I guess, a slang word for a rug, correct?
Yes.
The actual lyric is Ain't Poppin' No Tesla, isn't it?
I'm the judge. Can we look what I would not, and I'm Bree, I would not know.
It's page 2 of the transcript. It's the very last sentence of the first paragraph.
The judge. Do you want to look at it? Do you have the transcript? I'm Bree. Is it the big one?
No, it's the...
I'm the judge. I will give you mine. It's on the second page from the top paragraph. I'm Bree. Okay.
And so if you look at the very last sentence of the first paragraph of the second page, it's on the right-hand side. Isn't it true that the actual song lyric is Ain't Poppin' No Tesla?
Yes.
Okay. Isn't it true that this is a song from early 2025?
Objection. Lacks personal knowledge as to when John produced this song.
I'm the judge. Have you ever seen this song prior to March of 25? I'm Bree. No. Judge. I guess heard the song prior to 2025? Bree. No.
Had you seen the music video prior to 2025?
No.
Had you heard about the music video prior to 2025?
No.
And he doesn't reference you by name in this song at all, correct?
No.
He doesn't reference any children in this song at all, does he?
Not the part that I heard.
You had testified that some of the men in the March 25th, 2025 live stream, you named them Jordan and Itai, were your managers. That's not accurate, is it?
It is accurate.
Wasn't Itai your boyfriend?
He was not.
So you were never in a relationship with Itai?
No. This is the judge. How old are they? Do you know? Jordan and Itai. Bree. 22 and 21. The judge. Can I assume that neither one has a legal degree, correct? Bree. Correct.
Thank you. I have nothing further.
Anything else?
No.
May she rejoin you at council table?
Yeah.
Miss Olson rejoins council at council table as the judge. All right. Are you calling any other witnesses?
No.
Okay. Are you going to call your client in rebuttal and then we'll do evidence?
Yeah, just very, very briefly.
Sure. Mr. Gacy?
John?
Do you want me to leave the transcript? Are you going to use this?
No.
Okay. Mr.
John?
Gacy. Mm-hmm.
John, is there a difference between your professional personality and what you are feeling in your personal life?
Yes.
What is that difference?
Well, online I smile through everything and I get through it the best that I can. I have a son looking up to me. Social media is my job. I'm not going to go in there showing fear. And especially if somebody's admitting that they are trying to get a rise out of me. Why would I show that somebody is getting a rise out of me? If somebody's trying to put fear in my heart and I'm raising a son, I'm going to raise my son just how I am. I'm not going to show anybody that I'm stressed out. I'm not going to show anybody that they put fear in me. I'm not going to show that I'm scared. It's my job to show up to work and not show this emotion, just like everybody else has a job to do and not be emotional. They have to get the job done.
Okay, I have nothing further, Your Honor.
Any reexamination?
After you got Winter back, back on the 25th. You sent him back with your mom to Texas, correct?
Objection. This is outside of the scope.
Sustained.
Nothing further.
Okay, you can resume. Mr. Geezy rejoins counsel at the counsel table. All right, are you offering any other witnesses?
No, Your Honor.
Anything else, miss?
No, ma'am.
So do we now want to go through all the exhibits? And then I'll give each one of you an opportunity to argue.
That's perfect.
I appreciate everybody being so... What?
Conscientious.
Conscientious of time today, so we can get through everything much easier.
So, do you want me to just list the exhibits that I had, that I used?
Yes.
So, let me pull my exhibit list up for this. Give me one moment.
We can do it in numeric.
Right.
And then I'll hear Miss Fonseca's objection to individual. Let me ask just a global issue, Miss Fonseca. As it relates to pretty much all of the video evidence that she sought, including the clips, and I will tell you again, the only thing the court, because I know there was a lot of hearsay and back and forth, there was potentially crosstalk. Are there individual ones you have objections to? Do you have all of them? I'm interested to hear what your position is as to them globally first, and then I can take them individually.
There was just a few, and I'm trying to be fair, trying to stay within the confines of our joint statement.
Sure.
Because we did mutually agree to things in advance before we saw each other's stuff, but that's just what we did.
And the court appreciates you both.
So there was, I think, maybe 3, and as she goes through them, I can speak up as to which those were that were completely third-party streams or content that do not fall within the expectations of our joint statement.
Okay.
But the rest of them are probably fine, but I have them marked, so as she goes through them, I'll say,
wonderful.
Sure.
So, I have all of the portions of Exhibit 64.
Well, can we start numerically?
Yeah, let me go in order. I have Exhibit 16, which I think, already admitted.
Wait, what is 16?
My client's DVRO request?
That one, yes, we did admit that.
So the DVRO 16, which included his declaration, and that came in initially without objection.
Correct.
Correct.
Okay, that's admitted. Exhibit 16 is admitted into evidence.
I may have mine in reverse order, so give me a second to sort through them. Okay, I have 31.
Any objections? Looking, yeah, that's one of the third-party ones. That's Vale's TikTok. This is the one in the kitchen where there's 7 bait people all chattering at the same time. So the requirement under the joint statement to bring in third-party content like this was that there was a nexus drawn between client directing the third party to harass or threaten.
That's not accurate. Our stipulation allows threats by a party to be admissible, even if they are made on a third-party social media account. This is a recording where Brianna says, "No, I just said I'll piece his mom up any time of the day."
All right. So the way I see this is, just so you all know where I'm I I heard, with one or two exceptions, which I'll talk about when I make my ruling, I saw very little of any evidence that Miss Olson was directing other people to do this. There were one or two exceptions, but I think, and most of them, it sounded like people were doing it on their own, including Santos. He was all there. They were all doing it, kind of their own violations. But that doesn't take away from the fact, the specific statement of Miss Olson, specifically, no, I said I'll just piece his mom up any time of day. Those were her words. She also said, I made his mom cry several times. I don't know what the basis of that, I mean, it's hearsay, but it's offered against her, and she's a party client. So, what would be the basis of objecting to that?
Relevance, not a CHRO with mom.
I understand that. I'm going to overrule. So, 31 comes in only. It's really her comment of, I made his mom cry, and it said, I'll piece his mom up any time of day.
My other concern is I think the smaller numbers were in the grouping from Friday, and all the transcripts, per what you said and what I also acknowledged about the transcripts, were grossly wrong. So any exhibit, and we weren't presented with corrected transcripts of anything that was shown on Friday.
They were not grossly wrong. That is not an accurate statement.
Well, they weren't 100% accurate, but they were transcribed by AI as opposed to a human. But I will say this, I went through them and was very meticulous when they were inaccurate, and I corrected them. So, for example, on this one, the friend said, are you nervous? And then there's a reference to and 30 babes. But I don't really, in this particular case, care what the friend said. I heard nothing that was inaccurate as to, oh, I made his mom cry several times, and I just said I'd piece his mom up any time of day. Now, what's introduced is not the transcript. What is introduced is the actual video. So that's the clips she's introducing. So that's overruled, okay?
And I missed one. Exhibit 26 was where she talks about John's mom saying she needs to do something with her fat ass. Get a fucking 360 lipo. Brief fat back transfusion. She's not gonna do shit. She's not gonna do shit. I believe Miss Olson testified at least that some of these comments she did in fact say.
Okay. Where is that one?
Exhibit 26.
Okay. Again, I just, from a relevant stand, that's the one where it was inaccurate, where the transcript said a rack, okay, and I heard, okay, man, run it up, okay, and then it says I will, period. Because the original transcript was I will fuck his mom, I wonder if that's Itai. But the way I heard it was I will, period, fuck his mom. No need to shut the fuck up. You need to shut the fuck up, dead ass. You know what? Again, I understand Miss Fonseca's objection regarding relevance of the mom's comments. The comments about the mom that are potentially defamatory are completely irrelevant. Because as I said before, I don't believe defamation is the appropriate basis upon which to judge this because their First Amendment right and given that they are public figures. However, there have been allegations of threats. Thank you, love. And it's threats. There are transcripts that show allegations of threats made by Miss Olson, both towards Mr. Gacy as well as towards his mom. So I sort of, and then she said she was joking. So to the extent that this video talks about threats to his mom, though I'm not really sure, because here where it says, I will fuck his mom, it was inaccurate. It says, I will period fuck his mom. The relevant portion is, no, you need to shut the fuck up. No, you need to shut the fuck up. Dead ass. That could be seen as a threat.
Okay.
So that part is relevant. Exhibit 26 is admitted into evidence. Let me take a quick short break here again. You guys, this is where it gets kind of confusing when we're reading transcripts. I don't know how they do it in there because they never really make like full sentences. And so that was very confusing trying to read what they think it said, what they thought it said. But I just want you guys to know we're reading verbatim, word for word on the transcript. It's not that we're messing up what it is they're saying. That's legitimately what it says. Okay.
I think where it gets difficult for us to read it, I think that's whenever like attorneys and the judge are kind of like running their sentences together and like interrupting each other and conversing, but it's not going to show that really in here.
Right. Agreed. Okay. Miss Budnick.
And just so the court is aware, one of the other acts that can be enjoined would be harassment. And so I think some of these messages, coupled with the threatening conduct, it shows the level of harassment that my client has been going through this year. And so that would be my other argument as to why it is relevant.
Harassment? And that's why I hope maybe after the break, you can come back with some case law specifically. But again, I've tried to find every single case that I could find of DVROs in the sort of First Amendment Facebook posting kind of thing to read it. My understanding as it relates to harassment, I don't know. I'd like for you to look. My sense is when they talk about harassment, they talk about direct activities, annoying phone calls, direct text messages, emails, things that are directly conveyed to a particular person. I heard testimony that he blocked her. I never heard testimony throughout this entire time that we've been together for 4 days that she made any other than some communication about W, which were very polite and professional on both their parts. I never heard any testimony of her texting him, emailing him, any sort of direct harassment. There is only this very sort of vague vein of potential threats made. And she posted with maybe an understanding or maybe not an understanding that he would see this. So I'm not sure. And that's why I asked that. Maybe at the break, you bring me if this would be necessary. Because those cases that I read that talk about the use of social media, more like texting, emailing, social media, it's a direct contact. It's an annoying phone call. That's where the harassment is, I think. So I would maybe not. I would ask you to maybe cite me some case law that you could tell me it may be. It may not be. I'm not sure, but I'll let you argue it.
Okay.
Go ahead.
So the next exhibit would be Exhibit 31, which we just talked about.
And you object to that, Miss Fonseca?
Oh, Vale's TikTok live? Yeah.
Okay, that comes in at number over respondent's objection. Exhibit 31 is admitted into evidence.
My next exhibit is Exhibit 34.
Ms. Fonseca?
That one's fine. That's the boat one.
Okay, that comes in. 34 is admitted into evidence.
Okay, the next exhibit is Exhibit 35.
Which one is that? How does it start?
It says we don't call him 2K anymore. We call him 2Gay. And I guess in anticipation under relevance objection, my argument is that I do think this speaks to the harassment conduct and also conduct of that disturbs my client's peace.
Relevance, because how forward the court was about this topic and a couple others that were brought up in the first
Can you hear me?
day of testimony.
Yeah.
Okay.
We didn't go into this because it was labeled as defamation, so relevance.
Isn't that defamation?
Not necessarily. I mean, I think it can be harassing also, and it can be conduct that destroys somebody's home.
It's defamation. Didn't we have a long conversation about defamation and the case law?
Just because something may or may not be defamatory doesn't make it. They're not necessarily mutually exclusive. Something can be both harassing and defamatory, disturbing and defamatory.
So, do you have case law for that in this specific context of social media posting by public figures? Because there's lots of case law in this area.
Specifically, social media posts of a public figure, no. But I think just for the argument, I believe that there should be. This isn't a situation where my client.
Case law, counsel, respectfully. There's lots of case law.
I understand.
There's the Crucio matter and
I read the case.
So it doesn't come in, right?
this is being excluded as irrelevant to what is being sought here. So number 35 does not come in. Exhibit 35 is not received into evidence. Okay?
36.
Ms. Fonseca?
The chicken wing one, sure.
Chicken wing?
She was eating chicken wings on camera. That's another one with the messy transcript.
So confused why Ding Dong can't live with his mommy. So, what the fuck is the issue? Is this anything? Huh?
Go ahead. I was ahead of you.
Oh, okay. I was like, what's happening? Okay, I'm going to start all over. The judge says, so confused why Ding Dong can't live with his mommy. So what the fuck is the issue? Is this anything other than defamation?
I mean, she calls him a dumbass bitch and a ding dong. Again, I don't think that that's defamation. I think that's harassment.
Under what case are you?
Under the defamation of harassment, it's, I believe, and I'm doing this just off of memory, but I believe harassment is a course of conduct that is intended to annoy somebody, right? And so calling somebody a ding dong repeatedly, calling someone too gay repeatedly, calling someone a dumbass bitch, that is a course of conduct that is in an annoying course of conduct that constitutes harassment.
Well, she doesn't object, so it comes in. Exhibit 36 is admitted into evidence.
37.
No, relevance. This is the essay one, and kind of similar to the too gay stuff when the court labeled that as defamation, especially after Dad testified it wasn't her making the allegation. It was a prior witness in this case. We didn't get to go any further into the essay stuff because again, it was labeled as defamation, so relevance.
My argument is the same argument I made with respect to the other ones, in the sense of talking about his hair, how he looks like a girl, essays women. I think that it is harassment. I think it disturbs my client's peace, regardless of whether or not it's defamatory. And then I think at the very end of the video, Brianna says, 2K, $20,000 if you can beat him in a boxing match. She's talking about encouraging someone to fight my client.
Here's the thing. The first thing, the court went into great detail about what my reading of the case law was. And I invited everybody to respond. Hold on. Let me finish. And we all briefed it. And there's cases. There's the Maldonado case. There's the Crucio. Is that the
Candinati? I don't know what word it
sounds good.
is. Something like that.
No, it was Crucio. To me, that's the one that is the most, because in that case, it was two, celebrities. She was a comedian. There was a Facebook post specifically about basically accusing the other partner of SA. And there's all that case law about defamation and the First Amendment and prior restraint. And because everybody, whether you disagree with me, nobody provided me case law to say differently. And so Ms. Fonseca strategically, because she said she had there was one video shown of Mr. Giese saying some really awful things about Miss Olson's private area that could also be deemed as defamation. And Ms. Fonseca specifically said, I'm not going into all of that because of the court's ruling, number one. Number two, Ms. Fonseca attempted to try and show that the allegations that she alleged that Mr. Giese was gay was not in fact false and therefore couldn't be defamatory. And in an effort to try and refer to his OF account, I think to show that he indeed may be gay, bisexual, and I don't know. And I stopped that completely because I said the only part that may be relevant to this is in the defamation case when truth is an affirmative defense. So they made a strategic decision not to introduce that. I'm going to be very frank. I'm not going to rule on this case based on alleged defamation statements because both of them have said horrible things about each other online multiple times. You will not win if that is the only basis upon which you're speaking. Hold on, let me finish, please. It looks like you want to stop the court. You will not win. That is not with these two, because this is not a situation where one side says many defamatory things allegedly and the other side says nothing. They are both equally guilty of that. The main, and I've tried to tell everybody, and I want to be clear, threats are really relevant to this court because that's the exception, even in the criminal arena, when words are not protected. When words are used for criminal action, for either threat or things like that, that can be very well be an exception. But if we're using and relying on all of the alleged defamatory statements that she allegedly said to him, my sense is that Ms. Fonseca is going to ask to reopen all of the evidence and bring in all of the other statements that I'm sure are there based on a few that I've seen where your client also says defamatory statements allegedly. So I just think your focus, and if I can focus, you should be on. And I said that a couple days ago. I heard a lot of stuff that was not relevant. I heard a few, but I would focus on those.
So my purpose is really to make my objection on the record so that it's clear why I'm believing that these exhibits are relevant. I would agree that there's more that could have been presented that wasn't in terms of statements and name calling and that type of thing.
I will, on this particular one, on number 37, it will come in over Ms. Fonseca's objection, but only, I believe it's relevant, are sort of the last, starting where she says, like boxing. I'll give him 20K if he beats me. Okay, 20K if you can beat him in a boxing match. That's where it would be relevant. Exhibit 37 is admitted into evidence.
Okay, my next one is 38.
Okay?
No, that's another 2-gay one.
And I guess for the sake of having to repeat myself over and over, can I let the court know I have the same position as I've had with respect to 37 and 35 and the other exhibits that we're objecting to on those grounds?
Let me ask you a question. Did you have other potential defamatory videos
Yes.
that Mr. Giese said about your client?
Yes, we had additional information from his Twitter account and OF regarding him baiting gay men and going live about how they're his biggest subscribers.
No, that's not my question. That's not my question. Do you have alleged videos or statements of Mr. Giese saying potentially defamatory things of your client that you did not offer in because of the court's ruling?
Yes, and that was because of the court's ruling on the 2-gay and the essay stuff.
So that's the thing. We have all of this, and I know the court was being harsh at the time, but nobody gave me case law to say differently. So it's not fair. It's really not fair to them to then say, well, I'll still want to get in after the court's ruling. Well, or when they, we're at 3:30, 2:30 on the last day of trial. My sense is Ms. Fonseca is going to seek to reopen evidence if that's the case.
So my response to that would be the purpose of this, given the guidance the court has given us throughout this trial, would be that these posts are posts that dismiss my client's piece. My client is the one seeking the restraining order. Miss Olson is not. The fact that there have been posts allegedly where he may have said something about her, we have no time period, nothing. That does not negate the fact that his peace has been disturbed by her conduct. If her peace was disturbed, she could seek a restraining order. She hasn't.
Okay. What I would ask you to do then at the break is tell me why all these cases in the restraining order context specifically has specifically said that defamation is not the basis of the restraining order, because you have an opportunity to seek civil redress in a civil court and all of that. And if I stand corrected, then I'm wrong.
So, one case, for example, just off right now would be Parrish J versus Christopher Yu.
Yes.
It's a court of appeal case for the second district.
Very familiar.
Okay, perfect. So, among the context in that case, which the basis for issuance of the restraining order was a disturbance of the peace, these were text messages containing obscene language.
Okay, I'm going to stop you. A text message is a direct contact between somebody and somebody else. That's harassment. That's the direct contact. Public postings are First Amendment. You're bringing things into a public arena. They're First Amendment figures. They're public figures, so a text message is different. Something is defamatory if it's published. It's put out to the public. To say something to somebody else privately may very well not be defamatory. So a text message and public defamation are two different things.
Well, conduct that is Family Code 6320C defines disturbing the peace, for example, and that can be conduct that's communicated directly or indirectly. And so, if the language, as in the Christopher case that I just cited, it is this vulgar, upsetting language, and it's communicated indirectly, it can still constitute conduct that disturbs the peace of the other party based on how disturbing the peace is defined at the Family Code section 6320C, because it says conduct committed directly or indirectly, including through the use of a third party by any method or though any means, including but not limited to online accounts. And my read on the Caruso versus Pellis case is, in addition to the fact that it was a single post, whereas here we have a series of posts. It was private, and so the court it wasn't disturbing to anyone. Here we have many posts that are being publicly distributed. That makes them more upsetting.
That's the case. That's the case that you kind of implicitly ask us to bring to your attention for a separate reason. That's the case that defined the it's not an objective reasonable person standard. It is the specific mental calm of the party filing the DVRO. And like the court said as to the threats and actions taken in that case, they were of the traditional type, threatening to sue to recover money from their wedding, sending threatening and lewd emails and text messages threatening to throw out belongings after they separated, requiring police intervention. So, again, this is a case involving public figures and other people clipping what each of them are saying online and posting it, which neither of them have control over what gets clipped, what gets posted, and what the algorithm on these platforms put in front of them. So, because our trial brief was very clear in line with the court's perspective on all of this, that this was a defamation case tied up in a bow as a DVRO, we are not here for a defamation case. So, again, like the court said, based on the ruling as to the 2A stuff, as to the essay stuff, we didn't present any of our additional clips or testimony about that because the court already made a ruling. So I thought if the court made a ruling on the evidence, yes, I know we're going through the list of what to admit or not, but the court already made a ruling that this is not a defamation case. Those are defamation matters, so none of this stuff should come in, especially because we were not allowed to continue to put forth our evidence on cross on these topics.
Do you believe the fact in or the facts in Paris versus Christopher are similar to the facts in this case, Miss Budnick?
I don't think they're exactly the same. I think there are definite distinctions in terms of just the type of conduct. I agree, but I think the principle and the holding it in the holding is what is relevant, and I don't think that the conduct in this case is
in, oh my god,
incautious.
incautious, I guess.
All
No
right,
one ever
we'll
said
go.
it was incautious. That's a different story. So let me read you the specific facts in Paris, and this is why I think they are different. Unlike in this case, there's no evidence presented during this case of any direct communication between Ms. Olson and Mr. Giese other than in those talking parent messages, which on both parties' part were very respectful, professional, respectful. I filed the pleadings. Here it is. Thank you. Meet you there. There is no curse words. There is no too gay. There's nothing. They were very respectful. Here are the facts in the Paris case. In the Paris case. In 2019, the parties got into multiple disagreements, which led them to engage in heated arguments via text messages for several weeks. We have a situation where he said on the stand he blocked her. In his message to Paris, his direct message to her, Christopher repetitively insulted, berated, and demeaned her. That's harassment. That is a direct message to her via text message to her text. He accused her of cheating on him numerous times. On several occasions, he told her he was kicking her out of the home. Among other things, he stated he was going to change the locks, that he would not let her back into the home, etc., etc., etc. Then he said he also threatened her via text messages directly to her and email to her and told her that he would burn and donate all the things that he had sent to her. This is so different than the case we have because the only direct communication and contact between these parties that was presented to the court was very polite and very professional. So I respectfully disagree with you that the Paris versus Christopher supports that conclusion. And in fact, I think the seminal issue in Paris, or what the court was dealing with, was when talking about the emotional calm and how that is different than sort of the criminal, what they call, well, when they talked about whether it was a reasonable person standard, the issue in that case was the person actually, in that case, was the person actually disturbed. But this, I don't believe anywhere in here the word defamation even appears.
And I don't know why we would keep using the word defamation. We are not complaining about defamation. We are complaining about harassing communications that are communicated indirectly to my client, conduct that is communicated indirectly to my client that disturbs his peace, threats to my client that are communicated to him indirectly. We are not talking about defamation. We have not asked for a restraining order on the basis of defamation. That is a word that counsel keeps bringing up. That is not the basis for the restraining order request.
Okay, so number 36 is in.
38.
I'm sorry. Well, here's the thing. I think the basis of the objection is relevancy. I think to the extent it's part of this ongoing pattern, I think the court can find it relevant. Exhibit 38 is admitted into evidence. Whether that's the basis, I will tell you this. Those text messages of her, those messages alone, her calling him too gay, would not be the basis upon which this court would grant a restraining order.
Yeah, I would agree. I think granting a restraining order off of one of the indirect contact would be to Caruso and Pels getting a restraining order granted.
Okay, next.
Exhibit 40.
Miss Fonseca.
I mean, it's kind of the same thing.
So the objection is?
Relevance, yeah.
Okay, well, that's overruled, but the court will indicate what the basis of its ruling is again. The basis of my ruling, especially since your client specifically testified that the reason why he made the only alleged defamation posting that Miss Fonseca introduced was one where he talked about her private parts, and it is not in not a very flattering way. And your client said on the stand the reason why he did that was basically in retaliation for this text message. But it is relevant because it came in. So Exhibit 40 is admitted into evidence.
Exhibit 43.
Not text message, I'm sorry, posting.
Yes.
Any objection?
No.
Okay, that comes in. Exhibit 43 is admitted into evidence.
46.
I think these are the two that I thought were the same.
46 and what?
I don't know which one is 46. Oh, yeah. So 43 and 46 are the ones that I pointed out when they were originally shown that I thought were the same clip. She was wearing the sunglasses, talking to the chat and talking about kidnapping, but I think counsel says they are different, but they look like they were the same.
They're different words.
So they must have just been from the same stream. Then that's fine.
Okay, so 43 and 46 comes in. 46 is admitted into evidence.
56.
Now 56. Okay, I don't think which one is 56, please?
It is the one where she says, "No, bitch, you're trying to fuck with me and my kid, and I'll fuck you up, bitch. Whoever's listening, play this. I will burn your fucking city to the ground."
Yes.
Yeah, that's fine.
Okay, that comes in. Exhibit 56 is admitted into evidence.
Exhibit 57.
Miss Fonseca?
This is another one like some of those other third-party ones, and I don't know what the third-party exception is under our joint statement.
Well, again, all of these. The only thing the court is admitting into evidence is the statements that Miss Olson, unless otherwise. So you're specifically looking, Miss Budnick, for the statements, but then they're going to know I'm in LA.
Correct. And visibly, we saw the clip. We watched it. We saw her with W in a.
What's the
relevance?
Yeah, what's the relevance to this?
So it ties into Exhibit 79, where she talked about wanting to go to LA without telling my client because she knew it would upset him.
Okay.
I would still say relevance because she's never denied that she was in LA. So a clip of her telling someone else she's in LA, I don't understand the relevance to the actual restraining order.
Whereas I gave Miss Budnick a little bit of a hard time about the defamation, whether that's case law that concerns disturbing I think intentionally withholding a child and bragging about it.
Yeah.
could potentially be the basis of disturbing the peace, so that's overruled. 57 is admitted into evidence.
66.
So 57 is relevant to which one too?
I said it relates to all of the comments about napping that she made, and then the basis for why she actually removed the child from the state.
Okay.
What's the next one?
66.
I don't know which one that is.
She says, I'm going to nap him from the supervised visits in Dallas.
Oh, sure.
Okay, comes in. 66 is admitted into evidence.
64, and this, let me be clear, 64A.
No, 64 is the 3-part, and we need the actual timestamps that were used because I will note as they were playing some of the timestamps in here, they're not exactly the timestamps that I was given last night or this morning. So 64A through C is the I need the 2+ hours of stream.
Isn't 64A the one page?
It is a one page, and there is a timestamp where the statement from Brianna, the statements are shown. I did send counsel the timestamps as we acknowledged when we got here this morning, and I said these are the ranges approximately of what I'm using. We had a whole conversation about the transcripts. And with respect to all of the 64s, Miss Olson testified that these were her live streams. She made the statements, and I don't know what else we need to do to authenticate it.
Okay, here's the thing. Transcripts are required under the rules of court and as an aid to the parties as they're going through the videos, but the transcripts aren't admitted.
Correct.
The videos are admitted. The citations are, and I think as an aid and a guidance and a courtesy, for lack of a better term, to Ms. Fonseca. The fact that a timestamp may or may not be completely accurate does not prevent the video itself from coming in because Ms. Fonseca provided the video, I think, some time ago, correct?
August 12th.
Without timestamps. So, like I said, I didn't charge her to watch over 2 hours of footage because
Ms. Fonseca, respectfully, that's not an objection.
I know, I'm just restating what I said the other day.
But you don't need to restate it because it's not an objection. That is a strategic litigation tactic, but that doesn't make it inadmissible. Go ahead.
So 64A is the first of these parts. I have 64A through C.
Okay. Objection other than the timestamp issue, Ms. Fonseca?
If this is the water gun one, then yeah, that's fine.
Okay. 64A is admitted into evidence.
And then I have 64B. We also talk about a water gun. I only used page 4 for everybody's reference.
Ms. Fonseca?
If we're just talking about page 4 with the water gun, sure.
Well, I mean to be clear, I laid the whole page. She talks about blocking the street, yells, "Bitch, you're ugly," tries to zoom in.
These are the things I find relevant as to that page. Blocking the street in reference to the water so they can't come, so that can come in, sorry. Exhibit 64B is admitted into evidence.
Next is 64C. She talks again about a water gun and asks if it's an assault if it's assault.
That's not the part that was played.
Yes, it was.
Yeah, I remember assault.
You said you do or don't?
I do.
And then I played a second part on page 5 where she talks about, she yells that he's an abusive man who stalks her in reference to my client.
Well, there we go. I mean, it all goes back to the alleged defamation. The part I see relevant as it relates to the first page where she says, talking about kidnapping, not so much. They know I'm here, something. Guys bring me water guns. Is this assault? I'll let you argue whether she means it or not, but that page is relevant.
Okay, I have the next is.
Wait, hold on a second. I mean, I think. Do you want to play the whole thing?
I played. Oh, I gotta zoom in. Can't. I played the second section too. So the back of 4 into 5 about coming down to get the papers. It showed her interaction with the officers.
She just said that she played the first page, which was the part about the assault with a DW. So was that the first or 4 or 5?
I played 2 sections of this recording.
Was this the one where she is walking down the stairs with...
No, this was when she was outside and the officers come up holding papers, and she was asking them if she needed to come down, and they say they're trying to serve. This is actually, to Miss Fonseca's point, this is actually the recording on page 5 where they referenced music, and this is how she got into that. The video about the song.
I wasn't questioning page 5. I was questioning page 1.
Oh, page 1, I definitely played.
The court already said you remember page 1. So, of course, I'll take the court's.
Okay. 64C, page 1 and page 5. 64C is admitted into evidence. Don't you get irritated.
Okay, 64D. I played another section on, I believe it starts on page 6, and it again was a reference to spray him with a water gun. And then I think I went down, I played through this recording. There was a section about get his license plate in it, and then she says at the end, should I fight John right now? Will I get arrested?
Okay. Where's that? 64?
It starts on page, I started it on page 6 and then to page 8.
And?
I would say water gun is fine. Swag boy cues cars up there. Relevance?
Wait. So we start at... I'm at 60. I think I'm at 64D. The one that's like 9 pages, right?
Right. And I started at the end of 6 or midway through 6.
So, is not spending time with his son?
In the past page 6, I don't think this stuff was played.
I definitely played through to the end because the last 3 lines she says, should I fight John right now? Will I get arrested?
That I read. So I think from page 8 where she says, should I fight John now? Will I get arrested? Will I get arrested? That I have notes on. That came in. That is, well, Exhibit 64D has been admitted into evidence.
Can we take a 30-second break so I can grab my charger?
Yeah, absolutely. I was just going to mention that too. Okay, let's take a quick break, turn the comments back on, or turn the comments on. So if anyone has any questions or whatnot, I know it's kind of a lot going back and forth with everything. I want to also thank you guys so much for tapping the screens. Hi, Dominic. Tapping the screens, sending your daily heart me's for the gifts, for you guys just hanging out. Yeah, it's crazy. Like actually reading what's happening is crazy.
Yeah,
For
because
those,
as we're reading it, like for me, I'll read it and it's not processing while I'm reading it, and then I read it and I was like, wow.
yeah. So what we're reading for those of you guys who have come in while we've been reading, this is the actual court transcript from August. We have been waiting to read the transcript since August, like since the day they got out of court. Everyone has been wanting us to read it. Now, this is not the whole thing. This is only 113 pages of it. This is just one day.
Somebody asked what page we were on. We're on page 49 and we'll be starting on line 23.
Yeah. So again, it's a lot. Yeah, it's
Because I
not the
think
full
it's the
day.
last day.
Family, there you are. Yeah, so there will be a lot more to come. Hopefully, the attorneys will keep putting it out. If not, I don't know, because it's very, very expensive to purchase. I think they're like almost $6 a page. And again, this is only a half of a day, and it's 113 pages. So we will see.
I'm back.
Yay! Sorry when I was at the. Oh no, you are just fine, love. I wonder how many pages are. Oh, there's gotta be. I think I kind of like calculated before. Probably about 600 pages. What I think. Actually, well, let me run and use the restroom. I don't really have to. But let me run and use the restroom so I don't have to break again. Because we're about halfway through. So if you guys are all sticking, what does this little thing mean? What's that mean? I don't know. Anyways, me just pushing random ass buttons. Okay, so if you guys have any questions, you guys can chat. I'm going to run and use the bathroom real fast, and then we'll get right back to it.
Tanya, we had these sent to us from a friend via email. So I'm sure that Clippers probably, they have them, and some of them are probably circulating out there. I agree with UK.
Teresa, in the very beginning, I stumbled over my words reading something that Bree's lawyer said because I was like, wait, no, that's not correct. So yes, she lied a lot.
A lot.
Also, the fact of like saying that Itai wasn't her boyfriend, but then why does Santos have a photo of her and Itai sleeping in bed with the baby?
Yeah.
I don't sleep with. I wouldn't. I guess I don't have a manager, but I wouldn't sleep with my manager.
Hi, Four Sons. I read one part, the lawyer said, in other words, she didn't believe her.
Okay. All right. Did we get all of our questions answered? Again, I just have to say again, I so appreciate you guys for hanging out with us. I know a lot of people have already gone over this. I've received so many messages. I've been waiting for you to go over it, etc., etc. So I so appreciate you guys. And this, if you guys missed part of it, it will be up on my YT. I'll try to get it up there tonight. Remind everyone who. Oh, thank you, Beth. My sister is always the best. I am the judge and the witness. So I'll always, if a witness is speaking, I'll always say who I am as the witness. But I am the judge, principal.
I am Miss Budnick, John's attorney.
And I'm Miss Fonzica, Bree's attorney.
Okay, are we ready?
Yep, I'm going to turn the comments off.
Okay.
It's just easier, guys, because, like, most of you that are sitting in here hanging out or have all been respectful and everything. We just don't want anybody arguing in the comments right now because there are a lot of people in here and it can get super messy. So we're trying to keep it cute.
Yes.
Okay.
Okay, I think we'll be on line 23.
Yes, ma'am.
Okay, so Miss Budnick.
Okay. The next video was labeled 64E, and this portion I played. It was on page 6 when she says, I'm going to go to the courthouse tomorrow and file that he has to take a DNA test and he cannot get W then because I don't want to send my son to a stranger.
Okay. So that goes back to that language in Crucio versus Pels. In Crucio, I think it was Crucio because I highlighted it, where they talk about, when they talk about the language about the DVRO is not for every dispute. Custody dispute, yes. Okay. They talk about the guardrails and the need for guardrails in DV Acts, and it says courts are concluding that the DVPA was not enacted to address all disputes between formal couples or to create an alternate forum, for resolution of every dispute between such individuals. So that's Crucio 47 cal.app.5th at page 13. And in fact, to go back to your earlier point about saying that the Paris case was irrelevant, they actually, Crucio cited that the McCartney case talked about the defamation of disturbing the peace and talked about how it was Crucio. It said, it concluded that the ex-girlfriend's single private Facebook post, and I know you said it's not single, there's multiple.
Right.
Accusing petitioner of A being her is a far cry from the conduct described in McCartney and Elvis Zurzer. That's such a weird name. And she actually spells it out. It's spelled Evilsizor. It's almost like evil scissor. That's a weird name. Anyways, beyond that, thank you. Beyond that, the single post, there is no evidence that the ex-girlfriend sent the petitioner harassing, threatening, or unwanted texts or emails. That's the harassment. The direct contact with one to the other, and there's no evidence that the ex-girlfriend, and this is the other thing we talked about, there was a little bit of reference to doxing. If there had been doxing, maybe. I don't know if maybe, but there was not a lot. In fact, we asked about GTA publishing the address, and we didn't get very far. But they even distinguished that there was no evidence that the ex-girlfriend sent the petitioner harassing, threatening, or unwanted texts or emails, as in Barquette. Again, direct contact, sending something to somebody else directly. And there was no evidence that the ex-girlfriend published or distributed to third parties the petitioner. And this is key, private information. There is nothing about these parties that's private. And the issue in Evil Scissor was that the ex-partner, went in and basically improperly downloaded private messages off a computer and distributed those to somebody else. These are public figures, so that's the difference. And it said, although the petitioner was upset by the social media post for fear of her career, and that's a defamation lawsuit. And he talked about that. The court concluded it cannot set to rise to the level of destruction of petitioner's emotional conduct. Why do I say all of that? I just think they're different. I really do, because these are public figures. They both make their lives on the internet. They both say nasty things about each other on the internet. So for that to serve as a basis of a DVRO, again, I've said my piece.
The specific relevance to this section would be the statement that he cannot get W until then. This was made while the police were there and my client was waiting at the house trying to receive his son for 2 hours. She's now making a statement she's not going to release him until tomorrow, at least.
So you're saying that disturbs the peace?
Exactly.
Current case law, despite the language in Crucio that says DVROs are not meant to resolve every...
Well, of course they are not to. Caruso involved a single post that was it was isolated to a Facebook post. This is something that's happening in real time, in real life. The parties are on the same premises. The minor child is involved. The safety is at risk.
Okay, I understand. And you object because you don't think it's relevant?
Yes.
Well, that comes in and I'll let her argue that later, okay? Exhibit 64E is admitted into evidence.
And then I have 64F. This was that 5-minute video that we watched after W had been returned to my client.
The objection, and then we'll take a break. Let's get through all of the exhibits and then we'll take a break, okay?
I guess relevance, her talking about her mental health and the police interaction. I don't know what the relevance is of any of this.
Okay, page 6 is where I find relevance. I will fucking burn cities down to see my baby. I will literally burn this council. This is relevant. That is a threat.
Yes, I agree.
All of the other stuff, I'm not sure. This is relevant. That comes in. 64F is admitted into evidence.
73 was the post, the reading where respondent and Santos were talking, respondent, since we're only using her statements. Respondent says, we were trolling him and we were like, we're on the way. We made them go outside. And my client's testimony was that this was the day after Santos and Brianna had come to his hotel to threaten him. What?
Ms. Fonseca?
Relevance, not a CHRO of Santos, and I don't know if I have a transcript for that one.
I do.
Yeah, I do.
All right. This is very relevant because this is not just Santos. This is Miss Olsen, sort of. Whether conditioning or encouraging, it leads. This is the actual support where previously there hadn't been a lot of support. But this is the evidence that she either directed, condoned, or contributed to Santos showing up at Mr. Gacy's hotel. 73 is admitted into evidence.
Thank you. 74 was the actual footage that depicted Santos at the hotel.
Any objections in relevance, correct?
Relevance, and it does not come in under the exception of third-party content. Based on her testimony and John's testimony, she wasn't there. She wasn't in the video clip. She wasn't seen in the video clip. She testified she wasn't there. So the exception, again, under the joint stipulation, is third-party content that does not feature the other client or does not feature the party has to have some nexus between the parties, direction, and the content that's being shown as being harassing.
Okay, so your position is you previously agreed these types of videos would not come in.
Would not come in, but there is an exception. The exception is the nexus can be drawn between the party directing the third party to make a threat. And so, for all the reasons that I just listed, there was no nexus drawn. Both of them admitted that Bree was not in the video, seen in the video, heard in the video. there at the location in the video that we saw, etc. So I don't think it would come in. I mean, normally this wouldn't come in because of hearsay. So this was our built-in exception to third-party content coming in over a regular hearsay objection. But this does not meet the standard in our joint stipulation.
So are you offering this in the truth of Santos actually saying we're here at Sheridan Park Hotel?
No, I mean, my client testified that he reckoned his hotel in the back, recognized his hotel in the background. They are there, appear to be there. My client perceived this as a threat because he was at his hotel. He understood Brianna to be there that evening too. And this is related to Exhibit 73 that we just admitted, where Brianna and Santos are on social media talking about this incident.
He never testified that he believed that Brianna was there.
Yes.
Oh, hold on, ladies. Hold on. There's a difference between what you agreed to and whether the court can admit something over another party's objection. In that case, the court applies the rule of evidence. Okay, so it's weird that we're doing these in the form of transcripts. What you are really doing is asking the court to accept that clip, right? Of video. Correct, Ms. Budnick?
Correct.
So the clip itself, to the extent that the court reviews the video and the pictures and what it depicted and ignores the statements, it certainly can come into that point because you can introduce videos. She somewhat authenticated, or he authenticated it. And he said he recognized her. So it will come in for the sole purpose of the video depiction in there of Santos at the Sheraton Park Hotel. The statements that were here at the Sheraton Park Hotel will not come in because those are hearsay, though. It is somewhat corroborated by her prior Exhibit 73. But it will come in solely for what is depicted in the video. 74 is admitted into evidence.
Thank you. I had Exhibit 75.
Do you have a lot more? Because I do.
No, I have actually just 3 more. 75, 79, and 81.
Okay. Any objection to 75?
Oh, and 85. The OFW messages, which I think we're in agreement with, those have already been admitted.
I don't remember hearing 75.
Yeah, I don't know.
You guys don't have it? I mean, I'm reading it.
I don't remember. I don't think we ever introduced it.
Then we don't need to worry about it. 79. This is the one where she was talking about why she took W from Texas.
Oh, the podcast? Sure.
Okay, comes in. Exhibit 79 is admitted into evidence.
81 is Santos carrying Baby W talking about a dish track in the MILF house.
Relevance.
How is that relevant?
So it was posted on live social media. It's something my client saw while the minor child was being withheld there and removed from the state. It disturbed his peace to see his child unsupervised.
Then he can bring a restraining order against Santos.
Got it.
That does not come in. Exhibit 81 is not admitted into evidence.
Okay, and then the only other exhibit we have was 85, the messages.
The what? The messages?
Yes.
Any objection?
No, except I'd rather use ours. I mean, I know that those won't become public, but ours is redacted as to addresses and W's health information, and theirs wasn't.
The one relevance with respect to addresses is that the respondent twice told my client she was staying at a Texas location.
Counsel, we beat that horse for purposes of DV. TikTok, we did not beat a horse. Don't come for me.
There were no animals harmed
Yeah.
in the making of this video. Yeah, then we're good.
All right. Let's take a break until 3:25. All right, we're back on the record. Miss Forska, you want to go through your exhibits?
Yeah, so Exhibit A was the redacted OFW transcript.
Any objections, Miss?
No, I have no objection.
Hold on, give me 1 second. Whereupon there is a brief pause in the proceedings. All right, so we're back on the record. Exhibit A, the Our Family Wizard, correct?
Yes.
And no objections?
No objection.
Okay, Exhibit A is admitted into evidence.
Exhibit B, the monitor's report.
Did I even see those?
No, it was on our joint statement to come in automatically, and we tabled talking about them because you said that would come during custody visitation, but I know you're making some temporary custody and visitation.
Let's table those because I want to have a separate record in case there's an appeal for the DVRO.
Okay.
So you can introduce those monitored reports for the custody portion.
Okay, L. This was the TikTok comments made by Grandma that she was questioned about on the stand.
I would just object that they're irrelevant.
It was threats made by Grandma after they put up testimony about alleged threats made against Grandma by my client.
And I would object to the characterizations of the post as a threat. I believe it was a post saying she would seek grandparent visitation rights.
That's fine. I mean, none of this is helpful to me in deciding the DVRO, but that's fine.
That's why my objection is for irrelevance.
Well, I think she said in response. Anyways, they come in. Exhibit L is admitted into evidence.
P. The pictures of bruising on Brianna's face.
Any objections?
Yeah, I object. They were not authenticated. They lack foundation. I think her testimony was all over the place with respect to the dates, with respect to what was depicted. So I would object that those come.
Okay, before you respond, again, I'm trying to narrow down the scope of. I'm not taking anything away from Miss Olson to the extent that she alleged that she was physically AB'd by Mr. Giese. The reason why the court, as I'm thinking about it, kind of, I don't know if it is the best idea to open this, was to negate potentially because there's a representation of, well, we'll get into the DV. It would negate that, you know. His peace was disturbed, sorry, and all that, but I let it in. But I will say, and I'm not dismissing it, but it's not particularly helpful. She alleged he slapped her in the car. Then there's a video of him playing that. It may not have been the full thing. You can't hear it that well. I will say in the original testimony, the injuries are consistent with one slap. There's 3 separate bruises, and then she said that there was a different bruise. So I let it in because I say I'd let it in and it's consistent. Well, It's evidence in support of the testimony. I will say that that testimony does not help me in any way, shape, or form in deciding this matter. So I'll let it in, but I don't know what the relevance is. Exhibit P is admitted into evidence.
Okay, question. Can the clerk turn the sound back on? My staff said that they can't hear since we came back from break.
Or they can't hear over the very loud fan.
No, it's just muted.
Okay.
Exhibit AA. This is the clip and transcript of John talking about Brianna's sexual health.
I think the court.
Well, in fairness, Miss Budnick, you can't have it both ways.
I understand.
So if all of this, brief pause in proceedings. All right. Those come in. That comes in. Exhibit AA is admitted into evidence.
CC. This was the John's live with the transcript where he was playing a recording that he took of Brianna, which was regarding the incident that she testified about to the DV.
Miss Budnick?
I feel like there's so many foundational and authentication issues with that recording. My client wasn't asked about it.
Yeah, that doesn't come in because of, Exhibit CC is not admitted into evidence.
HH, the live and transcript of John regarding the justice to raunchy hoes.
I also object to that. My client wasn't asked about it. It's not authenticated.
Wait, what is the...
Was he? I'm sorry. I'm thinking of a different recording.
Hold on. What is the objection that your client was not asked about it if they introduced it? How is that the basis of an objection?
Well, I guess if the purpose of it was to the effect that she said she had when she heard it. That was hard.
Just because you opted not to offer and have your client, that does not mean she can't authenticate it and say, I heard it, I saw this.
I understand what you're saying.
Okay, that comes in. Exhibit HH is admitted into evidence.
KK, this was the video with no transcript because it was just music of Swag Boy Q recording John and John smiling at the camera outside of the MILF house on the day of the March incident.
I have no objection other than just to the recording depicts my client pacing and...
Okay.
And at one point he smiles.
Okay, that's not an objection. You argue so it comes in. Exhibit KK is admitted into evidence.
I understand.
Okay.
MM, this was the video and transcript of John and his mom and W being interviewed at Swag Boy Q's house right after they got W back in LA during the March incident.
Objection?
It was not an interview, but I have no objection.
So I'll take that as a no. Exhibit
Correct.
MM is admitted into evidence.
Correct.
In this, in the interest of time, we either have an objection or we don't have an objection. Objection. Go ahead.
RR, the video and transcript of John being live online talking about winning full custody.
I just don't have a recollection of this exhibit. I know that it was played.
RR, the transcript. Do you know the page on that, Miss Forensica?
Sorry, I think I can pull it up actually.
It's okay. I have it.
It's 639 in the transcript.
Oh no, I don't have an objection to this.
Okay, Exhibit RR is admitted into evidence.
TT was the video and transcript of John saying, I'm gonna take this baby and give it to my mom, and you're going to pay her child support.
I object to this on relevance. This was the clip that respondent testified actually was created before Winner was even born.
That's not as she testified. She testified she saw that in April. She did not testify as to when it was created. It was created by John.
All right, that doesn't come in.
Does not come in, you said?
Does not come in on a foundation issue. Exhibit TT is not admitted into evidence.
UU was the video and transcript of John's interview with Perez Hilton, where he said no comment and started laughing as to the question about DV.
That's irrelevant.
Well, it's not. Somebody saying no comment can mean many things. It doesn't prove anything. So under relevance, that does not come in. Exhibit UU is not admitted into evidence.
KKK was the video and transcript of John threatening Santos and saying he gave Bree the deal of her fucking life.
That's irrelevant.
Thank you. That would be my objection as well.
Not coming in.
So
What? I mean, tell me what the relevance is if he's threatening Santos.
we let in the clips, or we let in at least one clip of the reverse of Santos allegedly threatening John.
Right, but only in connection that I said. I was very clear when I said this is the one time where there is a connection between your client and something that a third party did, and so I connected the two. To me, that's like the Seminole clip.
The hotel clip and the restaurant clip?
No. Well, I don't know if it's the restaurant clip where she's talking and seems almost gleeful that they went to Mr. Gacy's hotel. That's where there's a connection between the two, but Mr. Santos is not. Mr. Santos is not seeking a restraining order, so that doesn't come in. Exhibit, I'm not going to say it, is not admitted into evidence.
Yeah, sorry I said it.
No, it's okay. It's okay. I was thinking that before. I'm like, no way that they're gonna have those together. But yeah, that's
I
crazy.
said it, and then my brain went like, oh no,
wait.
not that.
You're good.
The video and transcript of John admitting to embarrassing Santos online and making other disparaging remarks against him. That was PPP.
Same objection.
This is not about Santos. That does not come in. PPP is not admitted into evidence.
CCCC, the 8/22/25 Snapchat video and transcript of John advertising his Snapchat inside the courthouse.
Objection. This is irrelevant.
What's the relevance other than it was a really bad idea? It was in violation of the court order, and it may very well affect my decision.
Motive for filing the restraining order in the first place being for monetization and clout.
He can't demonstrate something that was filed in March. The motive for that filing can't be demonstrated by something that happened this week.
It's an ongoing motive. He's made repeated posts like this.
Well, look, by his own mouth, he said that he earned 6 figures just from the posting regarding the police standoff, for lack of better terms. I think there is sufficient evidence that he has profited monetarily from this whole proceeding, as has she. So that doesn't come in. Overruled. CCCC is not admitted into evidence.
HHHH was the music video that we watched today and the transcript.
Tell me how you think that is relevant.
So as to him creating this whole kidnapping narrative online, and I know you don't like that word, but that's the word that...
And I'm sorry, I misspoke. It's not that I don't like it. It's that the court never made that comment. But I understand your point, Miss Fonseca. Your point is that he monetized the word kidnapping, and that was all part of your position. I'm not saying I agree that he created this narrative online that W had been kidnapped and that increased the amount he received, correct?
And then never corrected it after we had that conversation with the court on May 2nd. So it goes to that part, and then to the he brought in the exhibit about, oh, I'm upset because Santos is allegedly making a diss track, yet he dropped diss track about Brianna the day he filed an ex parte for alleged kidnapping. And then impeachment as well the testimony he gave. I think 2 days ago I was disgusted that he was in the MILF house because I believe they use illicit drugs in there. And he's making or posting a rap video or whatever it's called, making drug references.
Wait, hold on. Sorry, I lost my line.
23.
Thank you. Okay, I'll let you respond in a second, Miss Budnick. Here's the only potential relevance of this. There was much testimony, and I think that kind of, again, but I still disagree with Miss Budnick's perspective regarding whether the alleged defamatory statement can be served as a basis for his peace being disturbed. To the extent the fact that he testified that he was upset and he was stressed, there were lots of videos about the exchange and how stressful that was. And my understanding was Miss Olson testified that she saw this video, sort of, in the court of law, that he doesn't look particularly upset or stressed. So it's relevant to that, but the rug thing, I don't know. It's never here or there. All right. Do you want to be heard anymore?
I guess there has been no evidence whatsoever that this song was created in connection with the March incident or the music video was filmed in connection with the March incident. My understanding of the music business is they take time to create. Music videos take time to create. The idea that this was a song that was written, published, distributed all on the same day is in connection with that. I don't think it's sufficiently authenticated to show any kind of connection to the incident.
The only thing that is what she testified to, what she saw posted, and what she believed to be his TikTok. I think did she say the 24th?
The 24th was the date on the video, yes. On his actual TikTok is where I accessed it.
So that was the day before this. All this drama. So it's relevant to that. It undermines potentially his credibility for that one. So HHH is admitted into evidence. Anything else?
No, that was it off of our list.
All right. Do you guys want me to give you a tentative, or do you just want me to, or do you just want to argue, and then I'll hear from both?
I think it would be helpful for me if the court gives a tentative, and then since we're already at 3:42, that would help.
Is that okay with you, Miss Fonseca?
Yes.
I want to make a couple perfunctory comments. The case I also went back and looked at was Evans versus Evans, 126 CAL.APP.4, blah, blah, blah. That's another case. It's a I think it's a DVRO.
I know. I read that. I just can't. I feel like I referenced that in the brief.
Right. So this is a case where it was a former DVRO, but he basically sued his former wife, alleging cause of action including harassment, defamation, and breach of privacy. And one of the things that he sought to enjoin her from was publishing false and defamatory statements about him on the internet, publishing confidential personal information, etc., etc., etc. And again, I think that case talk a lot about defamation and how you enjoin it. And the reason why I say all of this is the purpose of a DVRO is to protect the peace and to give them some peace and to give them some distance from each other so that they can, because what you're doing is an injunction. You're telling someone, don't do X. And historically, it would have been in the context of don't commit physical violence against somebody. And we're enjoining you from harassing, disturbing the peace, etc. But the idea is that the conduct that had occurred previously, which rose to the level of DV, needs to be enjoined or stopped for the parties to have peace. There has been no colorable evidence that Miss Olsen committed physical against Mr. Gacy. The large bulk of the evidence that I saw produced was in the vein of alleged defamatory statements. And so, in essence, me saying to someone, don't use physical against anyone, if I issue that order, it would be meaningless because there's no evidence she did that, has done it before, or will do it again. In terms of the sort of harass, destroy peace, well, harass, let's talk about harass. Most of these cases we talked about that I reviewed, and we've all talked about them, were cases where there was direct contact by one party to another, calling, texting, emailing, etc. And in those cases, the court said that in sort of this harassment pattern or conduct. Or we have a case like Evil Scissor, where you have a private figure whose private and sensitive information was improperly accessed by one of the parties and was revealed to the other, to like family members or things like that, and made more public, none of which is the case here. What we have is public postings by a public figure, as public as you can be on traditional First Amendments about another public figure. And that's where the First Amendment is aesthetic. When you're asking the court to, in essence, prevent words or speech, you have to be cognizant of the First Amendment and its protections, especially in a case like this. Not all speech is protected. Speech that is defamatory is not protected. But I believe the courts have said in Evans and others that your remedy to sorry, I feel a sneeze coming on. I'm trying to hold it in. Okay. But I believe the courts have said in Evans and others that your remedy to do this is not to enjoin it in the future because that's a prior restraint. And how do you do that? And the courts have said, the only time you do that is when the speech has already been determined to be defamatory. And I'm not going to decide because this is not a defamation case. And related to that is when someone successfully sues for defamation, one of the remedies, one of the damages is emotional distress. That kind of stuff that they're talking about, that's why you bring a defamation case. You said false statements to me on the internet. They were false. Did those you did those with reckless disregard for the truth because I'm a public figure. I suffered emotional damage, distress. Those are damages. That's not what you're asking for here. You're asking me to basically enjoin future conduct, enjoin basically similar conduct, and it'd be interesting to know exactly what you're seeking to be enjoined. I heard some initially reference to maybe she revealed naked pictures of someone. That might be because that's revenge porn, potentially. I heard no further evidence of it. I heard a little bit and I heard nothing after. I didn't hear, wait a minute, what's her name? I didn't hear when, I didn't hear by whom, I didn't hear how. I heard nothing more of it. And in fact, I also heard again, no disrespect to either party, that he may have had an OF account in which he may have engaged in sexual acts publicly on the internet. I'm not bad mouthing him for that. I'm not criticizing him for that. I'm not. You know, that is also a First Amendment expression, but that might have been, had there been more evidence that had occurred, that could have been the basis of the DVRO. I didn't hear enough to meet the preponderance of the evidence standard. What I did hear, and where I do believe the courts have said the First Amendment, and the First Amendment has a limit, is threats. Because there's all, and there is all this case law that talks about there is a different kind of criminal act that are based solely on threats. There's, let's just look at the penal code in California. Fighting words are direct. That has to be direct to a person. You said it to a person. I'm going to kick your ass. Whatever it is. But there can also be a lot of certain criminal threats. I'm going to I'm going to do this. I'm going to put you in fear of your safety. And those the courts have said are not protected. And in fact, if you look at sort of the categories, it's interesting. Because if you look at the categories of what can be the basis of the DVRO, in this case, we don't have the first couple, which is the sexual assault, physical assault, fear or imminent physical harm, those kind of things. What we're really all talking about is, you say harassment, but respectfully, and I know you guys will all research this to the hills. I have not been given a case which defines harassment in this context that we have seen where someone does not direct. Someone clearly does not directly make those comments to someone else or call them or email them. Somebody post something on something. I don't even know if she sort of said, I knew that he would see it. I don't think we ever made that connection per se, but because he said it, he said he blocked her. But I have not been given a case that said, in this context, her public posting is something that he may or may not see as harassment. So what I'm left with, and where I do think actually there is sufficient evidence, is these threats. And there were threats. There were several threats. And those, I think, and that's why I tried to telegraph everyone in the beginning, but everybody just kept doing their thing, and that's okay. But there were several of those, both to his mother, but most importantly directly to Mr. Giese, and I'll go through those. Let's see. Look, I think the most clear one is the thing involving the hotel, because that's the only time, I mean, there was a lot of testimony in the beginning about what Santos did and did not do. My sense is Santos is listening only to Santos. This court has made some orders. I think of not filming and understanding who's filming. You know, there is a lot of times where he was sort of doing it on his own. Mr. Giese provided testimony that he and Santos had beef, and so my sense is Santos did what Santos wanted to do on his own. Where I think that changed was the incident where the hotel change was the incident with the hotel, because that's where the testimony and Mr. Giese specifically said, I was at that hotel. They knew where I was. There's a video of them at the hotel. Mr. Giese says, I recognize the hotel in the background. And I'm not going to get into the statement that Santos said because I don't need to. There's the hotel. Mr. Giese identified the hotel. That's Exhibit 74. Then we have Exhibit 73, where Miss Olson's own words, and she said, and so then we were trolling him like, and she said, we. She may not have been in the video, but in this statement, she puts herself there. And she said, we were like, yeah, we're on the way. And then then we made them go outside because we're outside. And Chris did what he do. He got up and he knocked on all of the doors of the hotel. That telegraphs me she was there. She saw what happened, because I guess they're all staying next to each other. And then I guess this is, Santos says, bro, he was scared. He had to get out. And Brianna's like, come out, guys. We're outside. And so then she doesn't say they, she says we. And so then we made them go outside, and they were looking around, and they're so dumb. And and then she says, and then we posted the video of him fighting MA on our Twitter. So if y'all want to go see it, we posted the video, and yeah, wait, run my flowers. So that's troubling. And that's not really words, that's actions. So that, I think, even more so, takes us out of the First Amendment. And so I have that because she's also there. There were other statements where, okay, look at Exhibit 34, March 16th, prior to the incident with the police. Where my baby at? Dead ass. Bring my baby. Bring me my baby. I'm going to fuck you and your mom up. Not just the mom, him, dead ass. Fuck you and your fat ass mama. I'm going to fuck you all up. That's a threat. Let's see. 43. Yeah, we should just kidnap our kids. Yes, all right, fuck it. That's the plan. Count on it. Why? Do you think she's gonna clock me? Oh, that's good to say before court. It's a joke. We ride at dawn. I see that as a threat, sort of combined with everything else There were more. 56. I think Mr. Giese testified that he saw her around March 23rd. Brianna, no, bitch. You're trying to fuck with me and my kid, and I'll fuck you up, bitch. Whoever's listening to this, play this shit. Wherever you want to play this shit, bitch. I will burn your fucking city down, bitch. You're not going to keep me away from my child. You will go down with your fucking city. Dead ass, bitch. I'm actually fucking insane. If you want to see it, you can see it. I don't care. And then she says, she testified. She said, I wasn't talking about John Giese genuinely. I didn't find that credible. It was clear to me who she was talking about. I mean, there's a lot about that. And you know, the water gun, look, it's a water gun. I'm not taking away from it. And it seems like a joke to her. Maybe, maybe not. But she keeps talking. There's multiple things with the water gun. Should we hit him with the gun? The water pew-pew? Sorry, keep tapping, please, guys. Sorry. Should we hit him with the pew-pew? No. Save it for Jen. I mean, save it for, oops, I can't say. You know, the water pew is kind of neither here nor there. I think if it was a water pew alone, I think it would be. But to me, it's the water pew in conjunction with all these other prior statements about burning the city down and going to his hotel. 64A. Pew his mom straight in the face. She deserves it. And again, I don't care so much about the water pews, but again, I look at 64D at the bottom. Brianna, should I fight John right now? Yeah. Will I get arrested? No, don't do it. That is relevant. That is the kind of things that I think the court can use as a basis for a DVRO. Not all these sort of alleged defamatory statements. And then also 64. I think it is F or G, where it's the one that's 7 pages, and I'm looking at page 6, which starts with Swag Boy Q, and then she says, guys, seriously, in all seriousness, I will effing burn the city down to see my baby. I will legally burn cities down. Is she directing that to him? I don't know. But in conjunction with other places where she does, I think it could be taken, obviously, as a threat under the preposterous of the evidence standard. So I do believe the one. I think on her going to and she puts herself there. I think her going to the hotel alone would be enough. But there are other things that I've said, the statements, the threats that I've heard. There's one more. Exhibit 3. I mean, granted, it's more towards mother, but she says, PTSD, bitch. I've got PTSD, bitch. Your mama's next. I'm pretty sure that's referencing Mr. Giese's mom. Aw. Was that too far? Cry about it, ho. No, dead ass. I'm not gonna say anything. Never mind. She said some horrible things about being stuck up each other. Again, that's potential defamation. Could be disturbing the peace, maybe, maybe not. Then, Exhibit 75. Santos said, let me catch him outside. I know that's Santos, but Miss Olsen is there. She says he didn't say any names. And then she downplays it. No one's threatening anyone. We're not saying names. I don't think that's credible. And Santos says, I will whoop his fucking ass. Again, that cannot necessarily be attributed. That one is not as strong, but there is a number of them. There are a number. And I believe those threats alone, that is exactly the type of speech that is not protected under the First Amendment. It could be the basis of a DVRO. So I would be inclined to grant one on those bases alone. Let me hear from you, Miss Fonseca.
So back to the case that we talked about earlier, the one that Ms. Budnick brought up about the standard. It is the disturbing the peace standard of the person that actually filed the restraining order, not the reasonable objective standard. So regarding when he said his peace was disturbed, I guess we should go. And is this like technically our closing, or am I just responding to...
Oh,
Is it?
It's
wait.
the court, line 10.
How do I always go past it? Sorry, I was down on 16 already. Well, you can make your closing. I will say one more thing on that. Mr. Gacy testified that he was scared when they came to his hotel. That I believed. That I believed. That I believed. Because she was outside with Santos and somebody else threatening to. That I found credible. And to me, that alone, and I do believe what the case law says. It says it doesn't have to be reasonable, but the way I read it is that I have to believe that he actually felt that his peace was disturbed. And I do believe as that incident alone. So you can give your closing. I just wanted to telegraph what my tentative was if you wanted to address it in your closing.
Okay, so I can go out of the order. That's okay?
Sure, that's okay with you, miss.
I have no issue.
Okay, so it's a similar position that the DVRO was filed for an improper purpose, for content, for views, to continue to harass Brianna following the end of their relationship. I personally did not find he and his mom's testimony to be credible. There was a lot of conflicting testimony given between the two of them. For example, the 2K private investigator group chat that we talked about. That John testified about, where he said those were clippers that gave him free content. That makes my client look bad. When Grandma was called to the stand, the first topic that counsel chose to cover with her was that exact topic. And Grandma changed the entire narrative and said that it was just a family group chat in good fun and had nothing to do with the case. It was actually Grandma that testified about Dad having panic attacks. In all these different instances, Dad never actually testified that he ever had a panic attack. And he said he felt anxiety when random strangers flooded his chat feed. And then it was his mom that testified that he threw up on the day of the alleged napping incident. But his testimony, I don't even think he testified about that himself. As to the whole napping situation, the testimony confirmed from Grandma, Brianna, and John that the exchange in Texas was done between Grandma and Brianna because John was already here. Also, the end of today kind of confirmed why John was in LA. He was dropping a music video on the same day that he filed an ex parte motion. Brianna confirmed prior to the police coming to her house the following day in her testimony, and Our Family Wizard messages also confirmed that John did not reach out to Brianna except for one time on the 23rd, which was the day of the custodial exchange in Texas. On the 24th, when he was in LA dropping his music video, on the same day that he was filing the ex parte napping motion. He did not reach out to her at all. He never called her. He never texted her. She testified that Miss Budnick never called her, never texted her. She testified that on that day of the ex parte motion, the 24th, that nobody ever showed up at the MILF house to try to serve her with the order. Same thing on the morning of the 25th. She testified nobody ever came to serve her, so her first encounter with the orders was via our family wizard that morning, which John's testimony was, I was sick to my stomach. I didn't know where my kid was. I called a single welfare check to LAPD. I filed this motion. But then we see that our family wizard conversation between them tells a completely different story. They were talking leading up to the police coming to the MILF house that day about meeting at the police station. Brianna said that was too far. He's having a nap. John said you shouldn't have taken him. So just goes again to John's credibility about him being disturbed, concerned, bothered, etc., because they were, in fact, talking before the police even got to the MILF house that day. Brianna confirmed that she did not have a lawyer at any time during March. She did not have a lawyer on the phone, as Miss Budnick had tried to say in some of those clips that we watched today. It was her managers directing her as to what to do. She confirmed that Itai and Jordan were her managers at that time. Denied Miss Budnick's question about one of them being her romantic partner, and that it was those two that were directing her what to do, and she had to listen to them because she was under their management. There was conflicting testimony given between Mom and John and Brianna as to where everybody was during this encounter. Just goes to credibility again of the witnesses and how they were actually feeling regarding this incident. John testified on the first day that he is physically and mentally affected by his mother being John testified on the first day that he physically and mentally affected by his mother being mentally affected by this case and by the publicity, and that she has to turn off her phone because anytime something bad is said about her online, she's bothered by it. But then we have Mom or Grandma coming to the stand and confirming that on the day of the ex parte napping, RFO was filed. Grandma gave those documents to T-Pages voluntarily online before they became part of the public record. Told the T-Pages that the restraining order later that week was being filed, and her justification for this was because she was trying to get Brianna's attention. And then when asked if she was aware if John tried to reach out to Brianna at all that day on the 24th, she said she was unsure, but multiple times he had tried. But then we see on our family wizard that there was actually 0 attempts from Dad to reach out to Mom at all on the day that he dropped the music video and filed the ex parte motion. He said that his peace was disturbed when some TikToker named GTA threatened to release his address, claiming that Brianna directed this. It's important to note that in Exhibit 16, which there was moving papers on the restraining order, this allegation or this set of facts was not mentioned at all, even though Jones' testimony in the courtroom was that he allegedly saw this clip in December of 2024. Yet we know the restraining order was filed 3 months later in March of 2025. This was his most compelling testimony on the first day that we heard his testimony on Friday, but there was nothing presented in his exhibit list. He said there was clips. We saw none of those clips. Brianna confirmed that she doesn't know this person personally, only met him once in real life in a group setting. had no conversation with him, never directed him to say anything about her or about John online. John testified his peace was disturbed when Brianna was calling him an abuser online. He denied ever being in the car with Brianna in Florida when she was pregnant. We later saw him go live in one of those clips that we showed where he was talking about that exact incident, playing a recording from that exact incident. Brianna shared her testimony as to the physical abuse that occurred in the car when she was pregnant and shared her photos. We also saw the clip of John being interviewed by Perez Hilton about this, and he was laughing about it, saying no comment as to the allegations of DV. Said that his peace was disturbed when Brianna took W from California to Texas last November, but then Brianna confirmed through her testimony that there was no restraining order, no ex parte, no nothing done over this. So the timing of all of those exact things being done on the day after the music video is dropped, when John is already in LA per his own testimony, is questionable at best. John said his peace was disturbed when Santos was harassing him online. Then we went into extensive testimony about how they used to have a friendly relationship and friendly online banter, but that changed when Brianna and him broke up and she started dating Santos. And he continuously claimed that he was afraid of this person while simultaneously admitting that he taunts him online on purpose because he monetizes greatly off of taunting him online. So to the court's tentative about the hotel situation, another situation was Santos. Brianna's testimony about that was not that she was there, it was that the specific commentary about Chris knocking on the door and the "we" words was about the day before, not the actual video of Santos and another man outside of John's hotel. And again, John is claiming that his peace was disturbed because he was scared of Santos in general. He claims that his peace was disturbed on that evening that Santos was allegedly outside, but then he again says, I purposely taunt this person online for money. So I'm not really sure how credible it is that he is afraid of this person, or in particular, he was afraid of this person that night when he was nowhere in the video. He didn't come outside, and Santos was not here. Santos was not subpoenaed as a witness, so nobody laid foundation as to when that video was actually shot of Santos's phone. Do we know it was actually that night? No, we don't. John says he knows because he was staying in the hotel that night, but there was no, as the court brought up, no metadata from someone's phone, no custodian of records from TikTok or Snapchat or whatever that video came from, no subpoena to the party that actually shot that video to pull it up on his phone and show that it was that night that John was actually staying there. So again, we are missing a lot of pieces to connect the dots that was even an authentic video shot by Santos when John was actually in the hotel. And then certainly major credibility concerns regarding his alleged fear on that night, or just of Santos in general, when he says he purposefully pokes the bear online to make more money. John also said his peace was disturbed when Brianna accused him of SA online, but then confirmed through his own testimony that it wasn't actually her accusing him of SA on.
Counsel, respectfully, I know you got a lot, but I would like you maybe to direct your arguments to the tentative in my ruling, because I said the basis of my ruling is not these alleged defamatory statements. I mean, you can, but I think I've been very clear about the basis of my ruling. Really fast. Just so you guys know, we're almost done. There's about 11 pages left, so this shouldn't take much longer. I know it's getting late. I just wanted to let you guys know. Okay, sorry, go ahead.
You're good. Okay, so if we're just talking about the hotel then what I just said would be, I guess, my rebuttal to the court's tentative is Santos was here. He knows where Santos is. Santos could have been subpoenaed. We could have subpoenaed the custodian of records to Snapchat to verify a video was actually taken. Just because Santos posted a video showing a hotel sign does not mean he was there when John was actually staying there. John had offered no testimony to say, I knew he was actually outside. I went to the front desk and peeked out the window and saw him. I called the front desk and had security go outside and check. I had a note on my car that he left. He gave no testimony to connect the video of Santos, which, again, my client is not in the video. She is not heard off of the video. Her testimony was that the we comments and the specific comments about knocking on the door was a separate incident the day before, which is not the basis of John's allegation of fear regarding Santos, not an allegation of fear regarding Brianna. So again, if that is the hyper focus of the court, of what the court is saying is I guess, a credible threat or John's credible claim of being afraid, I would say we're missing a lot of pertinent details, which would be the authenticity of the person's body actually being outside of the hotel, making this threat when John was there because...
Hold on real quick. Sorry, hold on. Real quick. And then you also, just the other... I don't want to keep cutting you off, but I'm worried we're going to run out of time for custody and visitation, so I'll let you finish that. And the court's basis wasn't only that. It was all of the threatening statements that I read. So I don't think it makes sense to address the alleged defamatory because I was pretty clear about my ruling on that. So anything else on that,
So as to the two where she is wearing the sunglasses and says something about the kidnapping, her testimony was that she was reading the TTS, the live chat comments during her kick stream, making those comments, so that wasn't, and she also testified that was a joke. She never intended to kidnap W from his supervised visits in Dallas, which was another clip that they played, and that she was just reading the live stream chat during the sunglasses clip that we watched. And on the boat clip that we watched at the nighttime, well, I guess I should say, as to all these clips, she testified that W wasn't there and it wasn't her custodial time. But as to the boat clip, as she testified, she was just saying that if anyone takes her baby, it's going to be a problem. She didn't specifically say Jennifer. She didn't specifically say John. So I think that somebody that is served with a restraining order, ex parte, etc., within 1 month of giving birth after going through a pregnancy by herself, being in LA by herself, and all this being on the internet, certainly gives her an emotional basis on which to direct general comments, as she testified to the world that she is upset, that she feels like everybody is trying to take her baby away.
Did she have testimony that she was served with a RO 1 month after giving birth?
Yes.
No. The restraining wasn't even brought up. We had a lot of argument over whether we could even mention the prior RO. It was not even brought up.
I don't believe there was testimony.
There wasn't.
When was she served with the RO? And that was a month after giving birth. I did not hear any testimony. We're going to run out of time, so I'll give you a few more minutes because we still have to do custody and visitation. She has to respond.
So I think the only other ones left that you were mentioning is the 2 different video clips of her mentioning burning down a city. John's testimony and his mother's testimony was that we assumed that Brianna was talking about this about us and our city because we just made that assumption. There was no testimony that drew those comments to John or those comments to Dallas or those comments to Grandma. And Brianna's testimony was also that I was just making those comments in general. I wasn't directing them to anyone. To the court's point about the directness of alleged threats, this is Brianna talking and repeating what people are typing on a Kickstream in a live chat, on a Kickstream and live chat, and the other people clipping these and posting them all over the internet. Like the court said, John claims that she was blocked, but he also claims that he is continuously seeing this stuff. So I don't know if that's credible or not. But she's not making direct threats at John. She's not making direct threats at Jen. She might have called Jen fat. She might have said that she doesn't like John's hair. But that's not enough for a basis of a RO. Again, this is not a CHRO against Mom. Mom was never listed as a protected party. These are not direct threats. These are public figures. This is not my client ever once blowing up his phone, blowing up his text messages, having Santos or anybody else on her behalf doing anything like that. And the cases that we cited in our trial brief are clear in the RO context, and specifically the case the court kept bringing up today. The RO, I guess, field is not the place to settle disputes between ex-lovers. This is to protect somebody's peace, and I don't think that any of the testimony that Dad gave about his peace being disturbed, especially based on the week of the kidnapping and what happened during that week, was credible whatsoever. You don't drop a diss track about your ex-girlfriend the same day that you file an ex parte motion based on kidnapping and then stream the entirety of it and admit to making 6 figures off of it in a single week.
Okay, Miss Budnick.
So first, I do agree with the court's tentative that my client has met his burden to show that a permanent RO is warranted. Specifically, Family Code Section 20.6203 allows a restraining order to be reissued based on the types of conduct that can be enjoined pursuant to Family Code 6320. That section is very clear that threatening conduct is the type of conduct that can be enjoined. It's the type of conduct that warrants an RO. While I also believe that there has been harassing conduct, I think that it is neither here nor there at this point, because the important thing is that a restraining order will be issued to protect my client. The court needs to find one incident of AB to issue a RO. I know my client has presented evidence of countless threats, not just statements that are online bullying as they've been described or statements that disturbed his peace. We are talking about direct and explosive threats. I will fuck you up. I will fuck you and your mom up. Threats that are communicated on the internet and threats that are communicated in person and threats that have been communicated after the temporary RO was issued. A violation of a temporary RO also gives the court's grounding to issue a permanent RO. My client has effectively been terrorized by Miss Olson since January of this year. at least as far as the evidence we presented today. The threats predate the March 25th incident that we had focused on, and there are threats that occurred after the March 25th incident that we had focused on. I think he has had more than met his burden to show that the AB has occurred, and he needs an RO for his protection. And I agree with the court's tentative.
All right. Thank you. So because we went in a weird order, I'm going to give Miss Fonska the last word, but to say, if you want to contest anything she said or anything that hasn't already been said.
Just refocus on the hotel piece. That they had the opportunity to bring in this witness and to bring in actual ways of authenticating that video, and none of that was done. I assume strategically because John, again, did not testify that he had any basis on which to claim that he knew Santos was outside, besides the fact that Santos uploaded a video while he claims he had been staying in the same hotel. So honestly, for lack of a better term, I find that to be extremely flimsy evidence where this person is local. The metadata could have been subpoenaed. This trial has been on calendar for a very long time, so if that was their biggest piece of evidence, I would say that the connection to it actually being authentic evidence that he was outside, again, without my client there. My client nobody ever said my client was there, was off-site with the camera or anything. I just don't think they met their burden on that one piece of evidence when there are easily available ways to authenticate what they're saying was real, but those steps were skipped.
All right. Submitted. All right. Evidence can be authenticated a lot of different ways. Certainly, you can bring in metadata, but a party can also testify that accurately looks like the hotel I was at doing. I think he talked about a social media convention. There were also social media stars, including Santos. He testified he was there, and then shortly thereafter, we had Miss Olson's testimony. And again, it's not beyond a reasonable doubt. It's a preponderance of evidence. That fact that somebody didn't bring in evidence. In criminal law, there's a jury instruction not to necessarily consider all of the evidence that someone couldn't have brought in. There's also, even in the beyond a reasonable doubt context, the testimony of one witness can be enough to dispute that. Mr. Giese testified he was there. Mr. Santos, I don't know what his last name is, has put himself there. And then we have the corroborating evidence of Miss Olson sort of corroborating everything. But that wasn't the only thing. It was the other threats. And so the court, and you'll note, I didn't spend much time on what happened with the exchange of the child. I did not, because I think it was equivocal. And I think that interaction is the kind of thing that those cases talked about were not all custody disputes can be based on a DVRO. I'm not sure. And I'm not sure if it was awful to not know where your child was. But I do think that the physical evidence and the video we saw were not necessarily consistent with Mr. Giese or his mom not being particularly upset. They were live streaming. There was no evidence of the throwing up, etc. But again, that's not what the court focused its ruling on. It was the incident of the hotel and the prior threats. Of course, the behavior during that incident, the water pews, I guess, had some weight to it. Again, those alone may not have been enough. So, for all those reasons, I do believe it is appropriate to issue an RO. I will say this, it's going to be a short one. It's going to be a year. And I'm going to order you to do a parenting class, not a DV class, a parenting class. My understanding, I believe your client is with child again, correct?
Is what?
With child again.
Yes, she did do one of those paid parenting classes through Cornerstone that's on the
Stop.
court's list.
How? Sorry. How long was it? How many weeks?
It was private, like a private thing with the owner where they did private lessons.
Private sessions? Oh, sorry. This is Miss Olson. Private sessions, and I took a test. I think I offered to do them alongside John, which was the offer from the owner of the company, the court. Oh wow, I'm going to order him to do one separately, Miss Olson. I did one recently when you ordered supervised visits, the court. Good, Miss Olson. That's how recent it was, the court. Okay, because here's what I'm going to do. I'm going to make the RO valid for a year. We're going to come back in 6 months because under 3044, there is a presumption against joint legal and joint physical, and you can overcome that presumption with certain things. DV, which I don't think is appropriate here, but parenting class is. And also, if you come back and show me your parenting class, the court may very well consider changing the presumptions. We're now on to, let me read the order. Real quick because we're running out of time. I'm not going to make any special orders regarding enjoining particular conduct about posting because my fear is that will be challenged right away and may not very well be successful. I'm going to follow the standard orders in a DVRO. I'll leave it to both of you and you guys both have two phenomenal attorneys. You really do. And I will leave it to them to provide you guidance as to whether or not something is violating or not. So I can't prohibit them from posting. I recognize that's how they make their livelihood. I'm not going to prohibit them from making defamatory statements. I hope you wouldn't, because that's a separate issue. You have a child together and you have said some horrible things about each other online. Absolutely horrible. And now I'm putting on a different hat. I've now moved away from my DVRO hat and I'm on a different hat. I've now moved away from my DVRO hat and I'm onto my custody and visitation hat. That kind of stuff I can take into account when I make custody orders. So you both need to prove to me you can do a lot better as it relates to your child and what you say about each other. Because W is going to get old enough at some point to go look at all of that stuff. He's going to see what you said about his mom, and he's going to see what you said about his dad. Think about that. When he's 12 years old and he's in middle school and he's embarrassed and he has all of his new buddies and they're going online, hey, see that your mom said about your dad when you were little. Hey, see what your dad said about your mom. I feel sorry for him when that happens. So I want you both to think long and hard about that. All right? Miss Olson, you're ordered to not harass, strike, threaten, assault, sexually or otherwise, hit, follow, stalk, destroy the personal property of, keep under surveillance, impersonate, block movement of, annoy by phone or other electronic means, or disturb the peace of Mr. Giese. Disturb the peace means do not destroy someone's mental or emotional calm. This can be done directly or indirectly, such as through someone else. This can be done in any way, such as by phone, over text, or online. Disturbing the peace includes coercive control. Coercive control means a number of acts that unreasonably limit the free will and individual rights to the rights of the person protected by this RO. I didn't see any evidence of coercive control, so I'm not going to go through that. You must not contact Mr. Giese directly or indirectly by any means, including telephone, email, or other electronic means, except do they do our family wizard?
They do use OFW.
Okay. Except through OFW. There's an exception to that. You may have brief and peaceful contact with Mr. Giese to only communicate about your child for court-ordered visits. You may have contact with your child, W, only during court-ordered visits. We're going to talk about the visitation in a second. You must stay 100 yards away from Mr. Giese and his home. For an exception is for you to exchange your children for court-ordered visits. You must do so briefly and peacefully. For you to visit your child for court-ordered contacts and visits. I'm going to order you to do a parenting class. If you've already done one, great. At least 12 weeks. So I know there's private, but there are court-sponsored ones that I really would like her to do.
It was the facility on the floor of the LASC.
Okay? She can turn it into the court. We'll take it.
We already did file that.
Okay? We'll just put that already been filed. Do you have any objections to what are you aware?
I don't know the details of the class, and I think if it doesn't meet what the court has in mind, I can make my objection.
I'll say anything already completed may count. So I'm not going to make her do any more.
Okay.
Okay. Mr. Giese may record any communication you make in violation of this court. All right, here's what I'm going to do regarding custody and visitation. Right now, I'm going to award sole legal to Mr. Giese. I think I have found under 3044 presumption, but you can overcome that presumption. You can overcome that presumption by taking the parenting class. I am not going to order supervised visits anymore. My understanding is the supervised visits have gone well. There never been any physical harm to W as far as I can see. However, I do not like videos and pictures of your young child on the bed and people are vaping and smoking. My understanding from your attorney, you were no longer living in the MILF house. Is that correct, Miss Olson? I have my own apartment. The judge, wonderful. All right. What I would like to do, so I'm going to say no travel with W outside of the state of California during your custodial time in California. You're not going to have custodial time in California right away. You'll eventually get it, or you can't take W out of Texas during your custodial time. My sense is you've learned a very important lesson about the whole thing with LAPD. Thank God nobody got hurt, but they could have. There could have been. When our law enforcement shows up and says, says they're outside, it's not a joke. When I asked how old your managers were, I don't mean to be disrespectful, but a 21-year-old and a 22-year-old does not know about law unless they went to law school. They gave you terrible advice. I heard it all. You were lucky you were not arrested. You were lucky no one was hurt. When law enforcement says turn over your child, you turn over your child. You have to do it. My sense is because you're a public figure, you're not going to do that again because you know where to, or because we know where to find you. I think right now there is not a basis for supervised visits. I would like you to have overnight visits with your son. I know you're dying for him. I know you do. My sense is you're a different person now than who you were a couple months ago. You're a young woman and you're going to continue to learn. You have another child coming soon. You both make your living on the internet. I've heard so many things that just really cause me such great concern, but there's nothing I can do because you're going to continue to do it because you continue to earn money. And it is what it is. But I can take into account what you say and do on the internet in terms of when I award custody and visitation. You were not scot-free in this, Mr. Giese. You said some really horrible things. You made some really bad choices, I think. I understand that's how you make your life, your living. It is hard for me to, I will say it is hard for me to hear that you were stressed out about all these other things and then you're posting out in the hallway and you're making videos about it. It rings a little hollow. I mean, it was enough for the it was enough for the DVRO, but it rings a little hollow. So either you care about your child and you want to raise your child. Don't talk the way you talk about your child's mother on the internet. Same thing with you. You guys may ignore me because you make a lot of money doing it. That's your choice. But my sense is the other side will bring me in those videos the next time we discuss custody and visitation. That's why I'm allowing her to have unsupervised visits. What I'm going to say is, let's do it. What I'm going to say is, let's do. Sorry. Did you girls have a chance to talk about the meet and confer?
We didn't. My ask would be at least initially that the visits take place in Dallas, and I would ask for an order that Santos not be present at the visits in any capacity.
Oh, that's absolutely going to happen. I am not going to bash. I don't know if he's the father of your other child, but he's made some poor decisions. He should. I will. Why don't we put in the order he cannot film? You just said film was. I do not want Santos at these visits. There was already an incident. I don't know whose fault it is, but there are those people who are red flags for other people. He's a red flag for Mr. Giese. So you should focus your visits in Texas on your child and not Mr. Santos. So here's what I'm going to do. I know we were going to run out of time. All right. I was hoping you guys were going to meet and confer. I guess that didn't happen. So let's do this. I'm going to set the 6-month review date. I hate to do it, but I'm going to do it. Right now, all visits will occur in Texas, unsupervised. The parties can meet and confer as to the schedule for those.
Your Honor, that's not going to work.
Well, it's 4:30.
I know.
Counsel, respectfully, I said from day 1, day 2, and day 3, we're going to run out of time. That's why this morning I said I would like all of you to meet and confer. Nobody did. I'm at 4:30. I've given you guys a day longer than this case could have taken because nobody followed my order. So you're going to meet and confer. You're going to meet and confer. That is this court's order. All of these visits, we're at 4:30 right now. We had 2 days. We had all of lunch to work this out. You did not. I am not keeping my staff late because you guys didn't meet and confer. So all of the visits are going to be in Texas for the first 6 months. You guys will meet and confer as to schedule. If you can't meet and confer, my sense is someone will come to the court with an RFO. Well, when we'll do a 6-month review date, when she shows me proof that she's finished the parenting class and all of that, and assuming those visits have gone well, then we'll discuss visits in California. That will be the court's order. Let's get a review date.
In Texas, right?
Not Dallas?
Dallas. It's not in California.
No, because the airport
Texas is huge.
borders a county line. So the airport is actually closer to a county that's not Dallas County. So is it Texas as a whole or Dallas County?
This is Bree. I would have to get an Airbnb out in Dallas County where my family doesn't live in Dallas County. The judge, okay, where does your family live? Bree. They live in Corpus Christi, Texas, and they live also, the judge, where do you live? John, I live in Dallas, the judge. Okay, again, this is why I said meet and confer. It's now 4:30. Your attorneys were told at 10:30 today we were going to run out of time. I told them meet, they did not. I am not letting it's on you guys. Here's the order. If we met and conferred, we wouldn't be here now. So where does he live?
The child and my client live in Dallas. Corpus would require a flight. So if it's in the vicinity of Dallas and surrounding counties, I think that's probably a fair compromise.
Okay, here's what I'll do. I'm urging both of these attorneys to work together. The visits will be in Dallas and surrounding counties, except if you guys can work it out amongst yourselves.
And overnights, correct?
And they are overnights. They can be 3-day weekends. I'm good with up to 3 days. If she wants more, you guys can meet and confer about that.
Okay.
So at least, let's say once a month. It can be up to a week. This is why I said meet and confer. This is what I meant. I do not want to be doing this at 4:30, and here we are.
Okay.
So she can have at least up to a week-long visit a month overnight with, and maybe that will negate the issue of travel because if she has a full week, she can work out the schedule. The parties are ordered to meet and confer regarding that schedule up to a week, once a month, unsupervised in Dallas or surrounding counties. We will do a 6-month review date. Assuming those all go well, the court will switch and have some of those visits in Los Angeles, assuming she's still living there. Santos is not to be present at any of the custody visitation in Texas. That may change. My sense is that as she gets more pregnant, there may be harder issues with travel. Who the fuck is Travis? We'll address those when I think we can set this for the move away, because don't we need to do the move away at some point?
At some point, we're going to need final orders, so I think that would make sense. My only other question would be, can we get an order that Miss Olson provide the location where she'll be with the child via CFW?
Absolutely.
Okay.
All right. Let's do a 6-month review date, and maybe should we set that? Why don't we do this? I don't want to do a 6 months. Let's do a 3-month review, and at some point I want to, she's going to get more pregnant. And then there may be an issue with flying. Let's see how the Texas things are working. Miss Fonska can bring me all the proof and just argue it again about the parenting class. At this point, I'm going to set a PPA also, probably in conjunction with the move away. So let's do the first 3 months. She can CW up to a week in Dallas and the surrounding counties. Santos is not to be present at any of those visits. You have to abide by this order. It is going to be up to you to make a determination of whether what you post on the internet violates this order. You have a very good attorney next to you, and I'm sure she will provide you with that guidance. Hopefully, the parties can meet and confer on a holiday schedule.
Definitely.
Because I definitely don't have the time to do it. We'll set a review hearing date. You guys can always file an RFO. Well, why don't we just do...
I'm pretty open in January. It's just the last week of January I'm out.
My sense is on that review date, we will discuss switching visits to California. Can we do January 8th?
I can do January 8th. 8:30?
Yes. What day of the week is that?
A Thursday.
Okay, can you guys do January 6th?
That also works.
That's fine.
All right. Okay, so I think I've said enough. You'll get a copy of the order. I wish you all the best of luck. Remember, everything you post, the other side is going to see. And if the other side sees it, you can guarantee they're going to show it to me.
Is that 8:30?
Yes.
I think respondent needs to wait for the RO to be served. Can I pull a copy from the court's website?
Sure.
Okay. And that way we're not all waiting.
Okay. Best of luck to you all. Proceedings were concluded. Then let me see. What is this here?
It's just the reporter's thing.
Yeah, reporter's certification. It's just letting her know thing. All right. Well, so we can turn the comments back on. What I can say is the judge is feisty at 4:30. Like, she wants to be done at 4:30. She's ready for a snack. She wants a nap. She wants to get in her car. She don't want to deal with traffic. 4:30, she's done. Like, she was done. How many times did she say 4:30? Man, oh man. But I also agree. You guys, I couldn't help myself. You guys got me to 400 daily heartmeets. I have absolutely no idea what the daily heartmeet means, but I've never had 400. So I just want to say thank you so much. And almost 300,000 likes. You guys are fucking amazing. Okay.
Casey, I agree with you. I had a hard time reading her where I was just like, oh my gosh. And her closing argument, I was like, okay, we said this like 12 times. Let's move on.
But Bailey, I think you did so good because I literally, well, I've actually heard her talk now, but you have such a soft spoken tone that I legitimately can so see her speaking like you. You know, I think you did a great job playing her.
That's good. I was like, oh my gosh. And then I found myself just going monotone and I was like, oh my gosh, she just repeats herself so much. Like, this is ridiculous. Like, I get your point.
Yeah.
I don't know how you don't get your point. It's coming out of your mouth.
Right. But I think that's just like in courts in general. Like the judge repeats herself repetitive.
Yes.
Like everybody does in court. It's just kind of one of those
Yep.
things.
I feel like Miss Budnick, though, John's attorney, is really good. Like, she's straight to the point.
Mm-hmm.
She's got that feistiness, but she's also like, nope, I'm right. Listen to me attitude.
I love her. Just puts it right out there. And Principal is great for that role.
Yes.
No sparkles. You don't get the pictures and the videos. You get literally just the transcript of the writing. So now that's the end of it. And that's just the last day. So I'm curious when the rest of it is going to come out. Now I'm more intrigued and excited to hear and see what was said and what was done.
My hair is crazy. It's time for a haircut.
Stunning.
Towards the end, I was kind of shocked when at first the judge said 3 days.
For the visitation?
Yeah.
Right. Well, because typically that is how it's done, right? Yeah. You get 3 days every other week is where she was going with that, right? So she was going to get Friday through Sunday, and then she would have done that twice a month, I think. But then she was like, well, wait a minute, with the travel. But you notice how, first of all, not Bailey, but when she kept saying she's with child, she's like, what? She's with child. Yeah, she did a child custody. No! But she's trying to say she's pregnant. Do you notice how they never, every time the judge mentioned it, they never once said, yeah, I am. No, I'm not. I'm this far along. Just kidding. Yeah. I lied under oath. Like, none of it.
Mm-mm.
Yeah, it's, after reading the transcripts and, like, seeing the thought process of the judge, January is going to be interesting.
Oh, yeah.
I'm really interested to see how the first couple of days went, too.
Yeah, January is going to be so interesting. And I think that's why what's her name? Bree is trying so hard to get pregnant. What she's not understanding, that's great if you get pregnant now or next month or whatever. Come January, she's going to wonder why you're just now pregnant, because in August you said you were already like almost 2 months pregnant. So August, September, October, November, December, January. So 5 months. So you should be about 6-7 months pregnant come January, and you're not going to be.
Yep.
Which is going to
all the evidence of her drinking.
Mm-hmm.
Yeah. Oh, it was confirmed. It was already confirmed that at Jack's party, outside of like Santos saying what he said and get those, like a person that was there said, yeah, she was drinking, but why's the big deal? Because couldn't figure out why people kept saying, was she drinking? Was she drinking? Was she drinking?
Yeah.
Yep.
A mess. There was a few things I wrote down. One, I did want to talk about this because they brought this up so much, and I know for you guys that followed me way back in the beginning, a lot of people asked me, did I think Santos was going to get subpoenaed? And I said then, Bree better hope and pray to God he does not. Santos, Bree is her own worst enemy, but Santos is literally just nailing in the coffin, right? I said then.
It says by third party.
Huh?
It even says by third party.
Correct. But I'm saying Santos cannot control himself, right? So if he was to actually get up on stand, and John could have subpoenaed him, and I feel like John literally saved Brianna in this case by not subpoenaing him. He didn't need to because he had enough evidence, right? But he could have, and that would have completely effed Brianna even more, I feel like. So I feel like it was a good reason why they did it, and it cracks me up that her attorney kept saying, well, they should have subpoenaed him. He's here. Why didn't they subpoena him? They could have just asked, like, honey, you don't want him on the stand. No, so I thought that was very interesting.
He has no self-control.
Exactly.
None.
Yeah, and also the fact that she kept claiming that Itai wasn't her boyfriend, yet there's so much evidence on this app alone
that
they were together.
Every time she's gone to court, she's had a different man.
Yep.
Amy says, so do you think Vincent will move to LA in January because she has been breaking? No. I mean, who knows, right? I don't think that she's taken the course that she took is not a parenting class. She took a high conflict co-parenting class. A co-parenting class is just how to work with the other parent. It has nothing to do with parenting. But as I was reading that, I was like, oh, the judge kind of in a sense said, okay, we'll turn that in and I'll take it. I'm not going to make her take something else. But her attorney didn't say it wasn't a parenting class. She didn't say she did take a class, but it was a co-parenting class. She just said she did take
4 hours.
Yeah. It wasn't that. So when the judge sees that, I don't think that she's going to take it. However, I feel like she may give her another opportunity because of the way she worded it. I don't know. But if that's the case, you're going to have to go out another 12 weeks before they're going to be able to move it. But there's already, in my opinion, which means nothing, ask the people on TikTok, they'll tell you. I feel like there's been too many mistakes already for them to move it. And she's not pregnant. The whole reason why they wanted to move it is because she was pregnant and it was going to be harder for her to travel. Well, she's not pregnant. So no.
Yeah. So I think there was a lot that was in there that she claimed to get this easier, like every single little thing.
Yeah.
She lied about it. Everything.
Yes. Yes, Amber, they do have co-parenting classes. They have co-parenting classes and high conflict resolution co-parenting classes. They're amazing. If you have any troubles with co-parenting, they're great, especially if you guys can take them together. But they're great.
Exposing the lies said she really believes Brie had learned her lesson. And she did, but I was shocked. I was like, are you serious? Like, but again, hindsight's 2020, where we're now in the future and we see that she hasn't learned anything.
Hasn't learned a thing. When she said that, she said, I really feel that you've learned your lesson with LAPD. I'm like, no, she hasn't. Like, she hasn't learned a thing. Like, some of those, it was hard.
It's worse and worse and worse every time.
Every single time.
Every day.
Ariel, she took those private lessons on a live Kick stream, I think it was.
Mm-hmm.
Yeah, on Kick.
Yeah. Mm-hmm. Before court.
Mm-hmm. And Kat was answering her questions.
Yeah, I saw that, Teresa.
Uh-huh.
I'm not co-parenting. They have permanent legal guardianship. Yeah, I did see that today with I truly feel like with Brianna, when she wins something, she felt yesterday. Yeah, Natalie, what's your question? She felt yesterday that was a win. Well, it wasn't technically a win. It wasn't an emergent order. But the judge said file an RO, right? Because we just read the thing. No Santos around whatsoever. He has to tell her where she is. Hey, Tay, you have to tell her where she is, etc., etc., right? So she's breaking these orders. This is coming from the same judge that we just read said, absolutely do not do that, etc., etc. Then today, there's videos of her in a car with W in the car seat next to her, and then a video of Santos in the same car with the car seat behind her. So she's intentionally, at this point, she's like, fuck it, I don't care, because she feels like she got a little bit of wiggle room. She's going to just hang herself. Yeah, I don't think I have it on here. He deleted it. He deleted it, but we got it before he could delete it. Oh, wait, hold on.
They do that on purpose, though. Like, when it comes to social media, they're too smart.
Yeah, so here's a picture. It says, my driver is the best. Book him if you're in Dallas. But if you zoom in, there's the car seat.
Yep.
And then there's one. Do I have the one of...
John saving everything.
Oh, absolutely. Oh, I don't have the one of Oh, I bet you I can find it here. Hold on.
She really said they weren't in the same vehicle, so it doesn't matter. Of course she said that.
Oh, then she also said, though, I didn't know that she had said that. Someone else said, you guys act like we're in the same city. Obviously, we had the same driver in the same car. We're just not in it at the same time. Well, you don't rent a driver and that's just yours, and the car seat just stays in there, like as if he's not driving other people.
Because you've left so much the last week.
That's
You've
probably
just seen
where
you
he went the
everywhere.
last time. Like, he probably went and has, like, one of his friends, and that's who's actually driving.
Let me see.
Yeah, the court was not up to date with social media cases. Unfortunately.
Hey, what's this one? I haven't seen this one. Hold on.
Daddy's on the bus, say I love you, I love you, I love you. Daddy's on the bus, say I love you. Oh my god. Oh. He just like opens the door by himself and
Yeah, he's like, I want out of here. I thought that was gonna be it. Sorry. I'll have to see if I can find it, but there's one of her in the car with W in the exact same car.
What?
Yeah. I just saw it
Where's
today.
the comment?
Huh?
Somebody just said, if I was 2K, I'd request a new lawyer.
Oh, 2K's a lawyer is amazing.
Yeah, she is.
Yeah. Wait, why would you request a new lawyer though? I'm always curious on when someone what someone else. Oh, you mean judge, not lawyer? Oh, I was gonna say her lawyer's amazing. Lawyer's amazing.
Didn't
I
you
think
just get this judge?
No.
Oh, okay.
Had this judge for a while. I was thinking maybe for the ex parte, I was thinking maybe it was a different judge, but it actually was the same one. And I've received that comment a lot that he should request. Thank you, S. That he should request a new judge. Yeah, change the judge. The judge is actually really, really, really good. Again, I know it's kind of like the whole thing with the kidnapping thing, right? We all thought that should have been parental kidnapping, but it wasn't because there was a technical error, right? It's the same with this. And I said this actually before I even knew a motion was filed. I said, you can't really you can file a motion on this, but it's not an emergent need. In order to do it as an ex parte and have it be an emergency, the child has to be in imminent danger, like right now. If we don't do something right this minute, then the child can be hurt, injured, whatever. So FaceTiming Santos wouldn't really equate to that. Now, her moving, changing hotels and not telling him, maybe, but not really. I said, write everything down, every single rule that she's breaking, and just take the list in January, as long as she had the rule. And the judge agreed. She's breaking rules, but it's not an emergent need. You have to file it on a phone. So, here's the video that
Sorry. With the switching locations, doesn't she have to tell him, though, because she has to give the location?
Yeah.
Okay.
So she may have been ordered to she may have been ordered to tell him where they were or give the address to where he was, whatever. I'm not 100% sure. Here's the video I was talking about. And so this is the one with no, do you have the one where she's in the car with him? Maybe I've already been tagged. Let me see.
As long as the list doesn't go past 4:30.
Right. Yes. Cable before 4:30. I mean, I get it. She told the attorneys at 10:30 a.m. meet and confer, come up with dates and times, and bring it back. They chose not to do it, so she was pissed. Listen, she needed a Snickers, okay? And I needed a Snickers too, acting like her. Crazy. Since it's not considered an emergency, what would be? What would be considered an emergency would be like a I mean, it could be a million things, right? But like, for instance, when she took the baby to California and he was in that house with that type of activity around and all the rugs around and being on that thing 24, that was an emergent situation. So it could be if she's, she takes off again and has no contact or whatever, or can actually verify that Santos is there. There's something like that. Just the only thing that was written on there was, I saw a video that sounds like I recognized Santos's voice at the end. They were FaceTiming. She posted him on their group Snapchat, not her individual one, but on their family Snapchat. Those were the things that were on there. That's not an emergent need. Against the rules, but judges don't like it when we file something and that's an emergent need. So, why do they not show the clips that prove all of her lies? What do you mean, Melissa? Why do they not show, like, in court, you mean? Oh, they will. Oh, trust me. They will. They will show it all.
I think January is going to be huge. It's going to be huge. Yeah. It's going to take us 3 years to save up for those.
Right. She can't go to Corpus without permission, correct? That's actually I'm actually kind of, well, no, it says Dallas and surrounding counties, so I don't know if Corpus is surrounding to Dallas. I don't think so, but no.
No, it's a 7-hour drive.
Didn't it just say in the transcript? No, because that's a flight.
Yeah, that's what I was saying. I don't know Texas, so I don't know if it's a surrounding county. I don't know.
No.
And then this one is. Mm-hmm. Oh. No, go ahead, and then I'll read this question.
She did say, the judge did say that any travel they would have to agree upon right there at the end.
Right. And I think that was going to be for the holidays.
Yeah, I
think John would agree to it.
I don't think John would agree to it because Corpus Christi is right there on the border of Mexico. And it's far. He's not close. So if an emergency happens, he's at least 2 hours out.
Well, especially if she hasn't turned in her passport.
Yep.
Well, yeah.
I think that needs to be brought up too. If she hasn't turned in her passport, that'd be another one. Okay, let me read this one real fast. How is she breaking court orders and not being arrested, not letting 2K know moving? Because visitation and custody is all a civil matter. So she won't technically get arrested for it per se. She could, just depending. Like, for instance, if she tried to take him into Mexico, she can't do that. She could get arrested for that. She can get arrested for breaking the DVRO, which she's broke some of the parenting stuff, but not necessarily the DVRO. And some of that, even that, she's crossing the line. And there's a good possibility when she goes to court in January, if she continues on this path, if she continues to do some of the things that could be breaking the DVRO, again, stalking his Snapchat, that would be one of them. That could be an arrestable offense, and she could get arrested for that. If not, it could be a contempt charge. She could be held in contempt, which you could go to jail for that, or you could get a financial fine. There's a ton of things that you can do, but that's why.
But John has to file it and take it back in front of the judge and say, "Hey, judge, she broke the rules."
Mm-hmm. Or when they're there in January, they can file the motion then right before and do it that way. How do you think her not having a permanent address will affect? I think that's going to greatly affect her in January, right? Yeah. Because the whole thing was she has her own home, right? She brought that up. I'm no longer at the MILF house. I have my own apartment. Well, now she wants to live a nomad lifestyle. Why pay rent? Because I'm never there, because I travel all the time. Well, she has no stability for the child. Matter of fact, she won't even have a California address, and I don't know, because I don't know. I'm not in California, but I think John may be able to bring up a great point. She no longer has the California address, and all of her family lives in Texas. Why would we move? Why would we have visits go if she has to stay in an Airbnb anyways? If she's going to be in California, There's nothing that's going to hold her there. How am I going to know? She's already taken him out of state once. How do I now know that she's going to, that she could, she's not going to take him elsewhere, whatever? Because again, there's no stability.
Yeah, especially around here. It's all big thing. Like, they want to know where the child is. If the child is constantly moving, especially seeing how there's so much distance and she's spending so little time with him.
Right.
So the fact that she doesn't necessarily even really have a bond with him per se.
Yeah.
Someone sent you a video of Chrome where Chrome knocked on the door and you can tell she was hiding someone.
Let's see. Was I tagged in it or?
I don't know. She says she sent it to you from Mimi844.
From who?
Mimi844.
Let me see if I can find her. It's a Mimi03. Mimi. Let me see if it was.
Just commented again.
Tagged. Okay.
Here I am, was looking for it because I was going to pin it, but we're in the boxes, so.
I know.
Like, you can't do it.
Okay, so you sent to me in a.
Oh, you're so sweet, Hopeless. Thank you. I appreciate you being such a fan. Knowing every move I make and who I am. I appreciate that.
Wait, what?
Oh, nothing. I ruined platforms and Huckleberry's gonna take me down, so I don't know.
Oh, yeah, I saw her goons coming in here. I'm like, for what? Like,
yeah. Guys, just ignore them. That's exactly what they want.
They want their name to be said.
That's why they're so mad again. They're not getting enough attention.
Mimi,
I don't. They're not getting bored, but
I don't see it, love. I don't have a video from you. Go here.
Light on.
Like, to be that age and still be like, oh, let me try this. Hold on. Still be that obsessed and pressed.
Emily, I'm good, honey. Who said I wanted to get rid of you? Like, y'all need to grow up here.
Mimi, I don't know where you sent it, love. I don't have it. I just checked messages. I don't have messages from you. And it's not in my mentions. Let's see. Yeah. Sorry. Don't have it.
Very disappointed.
No, the transcripts from yesterday or day before's court will take months. These ones just came from August.
And it was only half of the last day.
Yeah. That's why my DMs were. Oh. I'll have to look at it, Unbothered, because I still don't have a clue as to what jump out.
I was catching up on stuff. There was Stars in the Sky Creations.
Stars in the Sky. Oh, here we go. Yeah, you can send that one. I got yours.
I don't
Stars in
know.
the Sky. I got your other, but I just accepted it, so you should be able to send one.
Would Santos dropping off food to Bree be breaking the court order?
Yeah.
Potentially. I mean, they'll play it off just like they did last time when she was on. He did it, remember, on supervised visits?
Yeah.
He dropped it at the door of the hotel and knocked and acted like it was DoorDash, but they filmed the whole thing. Like, that's why I say they always tell on themselves.
Yeah, and it's so dumb. Like, they keep trying to find ways around it where you could get around it. Just follow the rules for once. If you follow the rules once, it's all gonna go away. This
Yeah.
is all gonna stop. You're not gonna have to sneak and lie and connive and plot and skit. Like,
No, there it is.
But luckily for her, in her favor, they've always
It's gotta
found
be.
the little loopholes and stuff to get around with it. So she's never had any real accountability she's had to take.
Yeah. All right, here's the one that Mimi sent.
It's okay, Winter. At least you got our pictures.
And then I'll read
I know, his is kind of cooler
which
than mine.
other?
Mine's like kind of basic, honestly. I feel like if we were fish, this is what we would be. Are you spinning? Whee! Apple. 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 He says "abu" all the time, and I don't know what that means.
Peekaboo.
Right?
He did like it in the mirror. That's when we were doing our videos. How many times did what? I know. He's not.
This
I
is
don't
a
think
long
he's
video, but
peekaboo.
pretty sure he is.
He knows
I'm
what
going to
peekaboo is.
fast forward it a little bit because
Abu?
it's fast.
Abu. What does that mean? Pop, pop, pop.
Here you go. Boo!
Pops those little things.
Boo! I do
Just
it
bad
all day
word.
with my granddaughter.
He's trying to say that I'm his boo.
Yeah.
What's it, peekaboo? Oh,
Okay, here we go.
that's Chrome.
This is what she's talking about.
Boy. Oh.
If no
Okay.
one was behind that door, why would
she open the door? Who opens the door like that? You guys, we can block them. Ignore the trolls. This is what happens when you have people who want to be like us but don't know how to read and can't do this themselves. They have to stream me and then send all of their trolls over here, the 12 of them that they have. So just ignore them. The mods will block them. But nonetheless, why would she open the door like that to let the dog? Who opens the door when there's no? It's just the two of you. I would understand open that if you didn't want the dog in, right? But to let the dog in, to open it like that, that's crazy work to me.
Sparkle's also a puppy, like a puppy that chews, a puppy that is still potty training. Why would you leave a puppy roaming in a closed room? I wouldn't.
Oh, here's Stars in the Sky. Okay, and then this one.
I was like, oh my god, it hurts so bad. Like, it hurts so bad. I don't remember that, like, literally at all. Ow. Why do I not remember that? Like, hurting, or I don't remember it even, like, slightly. Or even, everyone's like, oh my god, it hurts so bad. Like, it hurts so bad.
Wait, what are we watching for?
I thought that intermittent fasting was fake until
Everyone's like, oh my god, it hurts so bad. Like, it hurts so bad.
Oh,
I don't remember
I
that, like,
didn't.
literally at all. Ow.
Why can't you put on clothes?
I should have watched that first. I typically won't ever. My bad. I don't put pictures of the kid, especially when he's just in a diaper. I don't know why she constantly has that baby just in a diaper. No, I didn't hear him. What did he say? No, I will never understand her just sitting in a motel room and having him on the bed.
always on the bed.
Always on the bed.
I remember
Blows my mind. The fear I have, even when the grandbaby, like, in the sleep, like, moves, gets close to the edge of the bed. Man, I just can't.
I remember
Yeah,
going
they'd
on
be
like
sleeping on the floor.
vacation. I remember going on like vacation with my daughter when she was a toddler at that age, and we were never in the hotel room. Like, I could not imagine being cooped up in such a small room with a toddler.
Yeah. I can't either. And that hotel clearly has another room. There's like a living room area, and then there's a bedroom. Yeah, we stayed in one just like that when we just went to California. There was a big room. It had a big, like the beds and whatnot, and bathroom is in there. And then you went in through the door, which you see when she opens the door. There's a whole nother room with a couch, TV, whatever. We turned that into the little play area for the kids, so they had a place to play and run around. Why? I don't understand why this kid's always on a couch. Why did she leave the big old Airbnb where he could play? I don't understand. Oh my gosh. And the pacifiers. Yeah, she literally does not have any maternal instincts. There just doesn't seem to be a bond there, which truly breaks my heart. I wish there was. If I kept my son in the house, he's a toddler, he's literally like, we got to keep him entertained, keep him going. That's why I tried to make a video the other day. They have this little slide that my granddaughter has on TikTok. Best money ever spent. Those, especially when we have all three of them that are a year and a half apart. 3 girls, a 2-year-old and 2 1-year-olds. They go run around, they go down this slide, and they have it on the TikTok shop. I try to make a video of it. Great. Gets all of her energy out.
Brandy, he does try to climb off the bed in the monitor's reports. Like he'll move around, and she would always pull him back into the center of the bed.
Yep. Blows my mind. I just... Yeah, me too, Chloe. I don't grasp that. Like, he hasn't been on a pacifier in forever. Like, she's like, well, he was fussy. And it says for 18 to 24 months, so no one can come for me. Well, yeah, except for you're not the one that has to deal with him now when he has to have it taken away. Now, thank goodness I haven't seen, I mean, I don't really watch her, but the clips I've been sent, I haven't seen him having it in his mouth a lot, so hopefully it won't be a big deal. Oh, I'm the same way, Emily. Yeah, I never knock having a pacifier, but if the child isn't on it and you only have them a few days and then reintroducing it, that's when it's bad. I think he goes back tomorrow. Right? He goes back tomorrow?
I think it was today. It was supposed to be the 23rd, but she went on that whole rant about how she messed up the dates and John wouldn't compromise.
Yeah, everybody was saying last night, I thought they said it was today. For some reason, I was thinking it was tomorrow whenever I first heard it, because I know that's the date that she gave, because it's somebody very important to me's birthday. Well, I guess it is. Happy birthday, Toots.
Wait, what? What happened? Who?
I said I was thinking the 23rd because somebody that's very important to me has a birthday on the 23rd. So I was like, oh, whenever I first heard it. So it registered. Happy birthday, Toots.
Oh, he's back with his dad now. Oh, good. Crazy. She doesn't know how to pacify. Yeah. That's crazy. There's a Snapchat that she uses John's name. Possibly, yeah. Can you send it to me, H. Hoover, and then I can find out. Wait, John, I'm getting confused. Your birthday's the 24th? Well, happy early birthday. Some people are saying that John made a video and he's back, and others are saying that he's not back till the 24th.
To kind of help boost you up just a little bit.
So I don't know. I don't know. Star on this guy sent you a message. Okay. Possibly. Okay. And then we will wrap up because...
I know, it's fine. I gotta jump out anyways. I need to check some messages that just came through while I was on live on my nephew. So.
Well, I appreciate, especially you're on the East Coast, so I definitely appreciate you so much for coming up. I appreciate you. Love you, girl. I'll chat with you tomorrow. I'm going to stay on, answer a few more questions for just a little bit longer.
Good night, everybody.
Bye.
Let me know what I hear. Updates.
Right. Angie, that girl is pregnant again. The one you called up. Stop it. Are you talking about Jadine or whatever her name is? Well, good night, MC. Are you going to sleep as well? I know this is a late night, but I'm glad we did it today, reading the transcripts today, because that would have been way too much yesterday. That would have been, no, I was too tired for all that. Yeah.
Hey, Angie, I'm going to hop off. I'm going to go to bed. I have to get up early for work.
Yes, thank you again so much, Bailey. I so appreciate that. I
You're so
absolutely
welcome.
appreciate it. All right, you
I
have a good
am
night, love.
more than willing to read more whenever you get more. Just let me know.
Absolutely. I will do that for sure. You were the best. I appreciate you. Oopsies, hold up.
Thank you.
All right, have a good night.
Bye.
Okay, here we go. Someone just asked for my email. Here it is. I will pin it. That's crazy. If she's pregnant again, because of the active CPS case she has, they will very likely remove at birth. Potentially, unless she changes, she goes through rehab, does all the things that she needs to do. But if not, there's a good likelihood she could lose child at birth. You called me today? I didn't get any missed calls. Doesn't mean I didn't have any. Listen, my granddaughter had me booked and busy today. Okay? We were busy today. Saying she was pregnant, was sick. Did you get my message? You guys, I have not been on at all. I'm so sorry. I have so many messages. It's absolutely crazy. I still haven't even eaten it yet again today. Here it is, 10 o'clock. Just no time. Baby Shark, that's a great question. Where are all the families of all these young girls that just keep having these babies and the kids are, yes, I do talk about Kira and Anti. Absolutely. Absolutely. I know. I don't really get hungry a whole lot though. Right, retirement is busy. I thought I was going to be just chilling, maxing, and relaxing, My birthday road trip changed. No, I'm sorry, love. Oh, I will. I'll eat. I'm just going to heat up the food I made yesterday. I get overwhelmed with messages. I do a little bit, but I also I do get overwhelmed with the messages because there's legitimately so many. It's like it doesn't stop. Like there's thousands. No, it's probably close to 1,000 total. Oh, Shelbs is on. Yeah, it's a lot. It is a lot. Yeah. Yesterday I made some like Greek style chicken and some potatoes with some naan bread. Thank you. This is just like my normal, like out of the shower, just put a little mousse in it and leave it down. I just hate my hair down because I hate anything touching my face. He wants to talk to you and nobody else. Right. Yeah, I wish that was it. Most of the time, that's why I don't watch like a whole, I do try to get to them, but it's a lot. Like I said, it's after 10 o'clock here, I still have to do dinner and whatnot. By the time I'm done, I'm ready to go to bed. And I'm not on my phone when I have the baby all day. And I get done with the baby by about 5:30 and I pop right on live. So there's like not a lot of downtime. But lately, the majority is just, thank you, stars, is people sending me videos and clips of these random yahoos just making false videos about me. Angie, how is your cat? Hope he's doing good without you. Yes, he is doing good. A handsome man. Oh, I do, Mimi. Thank you so much. Have I heard about Melody Buzzard? Who's that? Let me screenshot that so I can look into it. Yeah. Thank you, sister. You sent it? Okay. Let me look and see. Wait, did you send it in TikTok? Or did you send it to my email? Hoover? Oh wait, request. Oh, email. I'll have to look when I get off then, because that's in this phone here. So, all right. Do you guys have any other questions? Did you see the mom that was caught with the baby dolls? Yes. Oh my gosh. We'll talk about that probably tomorrow. That's a whole crazy scenario. You're talking about the one that went the entire pregnancy, did the gender reveal, the whole nine, even showing people the baby. Like nobody, not one person thought, that's weird. The baby doesn't move, make any sounds, nothing. No one thought, like people even touched it and thought it felt kind of cold, you think? Like, anyway, so I do want to talk about that. That is just crazy. She's a missing 9-year-old. Oh, God. And the mom won't give any info. She's like, wait, we gotta get to 300K. Okay, well, wait. We're almost there. We're almost there. We're almost at 300K. Oh, the other thing, too. Hey, we hit 300K. Thank you. What was the other thing, too? Oh, it's probably past. Oh, it did. It started over. I never pay attention to the, what's this called? Like the rankings or whatever. But while I was reading, that's why I kept looking up. I kept getting something that popped up because I think it was like towards the end, and it was like, you're like 2,000 points away from whatever it was, going to the next thing or whatever. I have no idea. Yes, great job, gang gang. I appreciate you guys all. You guys all need to go like stretch your fingers, do all the little finger exercises. You will be good. All right. Love you all so much. Tomorrow we'll get back to our regularly scheduled program, and we'll just continue on going from there. So you guys all have a great night. Thank you so much for the daily heart me's, for all of the taps. We got 406 daily heart me's, 301,000 likes. You guys are absolutely amazing. I love you so much, and I will see you tomorrow. Have a good night. Bye.